Okay, so I'd like to welcome everybody to this Monday, February 8th, Trust Ambassador meeting. So it's about 5 after, so we'll get started. Again, we're on the treatise on the law and trust by Lewin. And I think we'll maybe pick up on chapter 2, which is on page 20 of the actual document at the bottom, which is chapter 2, classification. It's a short chapter. It's only about 4 pages long, maybe not even that. Has anybody done a read farther ahead? Has anybody seen anything of real significance? Anything up there that kind of sticks out for you?
I, for one, have not read ahead.
Okay. I'm just about as guilty, so I can't complain then. Okay, chapter 2, classification of trust, page 20. So if we're all on the same page, chapter 2, classification of trust, page 20. It says number 1, trust simple or special. The first, a natural division of trust is into simple and special. Under simple trust, the simple trust is where the property is vested in one person upon trust for another, and the nature of the trust not being prescribed by the settler is left to the construction of law. And in this case, the city key trust has justice abandi, or the right to be put into actual possession of the property, and justice disputendi, or the right to call upon the trustee to execute conveyances of the legal estate as the city key trust directs. And I kind of like to point out that the W.8 Benz series IRS documents, talks about the simple trust, because that's on block 3 under part 1 of the identification of beneficial owner. And that last block clear on the right, it says simple trust. And on the instructions, I think it's on page definitions, page 3, where they're defining beneficial owner. And somewhere, let's see, where's it at in here specifically? The second paragraph, about 1, 2, 3, 4, 5, about 6 lines in, it talks about the foreign simple trust. The beneficial owners of the income partnership are generally the partners in the partnership, provided that the partner is not itself a partnership, foreign simple, or a grantor of trust. And then it says the beneficial owners of income paid to a foreign simple trust, that is a foreign trust that is described in section 651A, are generally beneficiaries of the trust if the beneficiary is not a foreign partnership, a foreign simple, or a grantor trust, nominee, or other agent. So they're defining who the beneficial owner is as a foreign simple trust. But it's interesting to note that the IRS is making reference to a simple trust. So continuing back on the treatise then, second paragraph or third paragraph where it says special trust now. Special trust is where the machinery of a trustee is introduced for the execution of some purpose, particularly pointed out, and the trustee is not, as before, a mere passive depositary of the estate, but is called upon to exert himself actively in the execution of the settler's intention, as where a conveyance is to trustees upon trust to sell for payment of debts. And now the special trust number 2, either instrumental or discretionary. So special trusts have again been subdivided into ministerial or instrumental and discretionary. And I thought right away, man, that's There's got to be a connection there. Discretionary trust is a special trust, which ties in with the Gilbert's law summaries there on discretionary trust. So the former, such as a demand no further exercise of reason or understanding that every intelligent agent must necessarily employ, the latter, or the discretionary, as cannot be duly administered without the application of a certain degree of prudence and judgment. A trust to convey an estate must be regarded as ministerial, for provided the estate be vested in this city key trust, it is perfectly immaterial to him by what manner of person the conveyance is executed. And the next section, trust is held by Mr. Fernie to be instrumental. A trust for sale was considered by Mr. Fernie as also ministerial, quote, the price, quote unquote, he said, is not arbitrary or at trustee's discretion, but to the best that can be gotten for the estate, which is a fact to be ascertained independently of any discretion in the trustee. But there is much room for judgment in the time and the mode of proceeding to the sale, and the precautions that are taken will have a material influence upon. Mr. Fernie's opinion cannot at the present day be maintained. And the next section, examples of discretionary trust. A fund vested in trustees upon trust to distribute among such charitable objects as the trustee shall think fit, or an advowson conveyed to them upon trust to elect and present a proper preacher is clearly a discretionary trust, or the section of the most deserving objects of the first instance and the choice of the best candidate in the second is a matter calling for serious deliberation and not to be determined upon without due regard to the merits of the candidates and all the particular circumstances of the case. Number 3, mixture of trust and power. Mixture of trust and power. There is a frequent mention made in books of a mixture of trust and power, by which it is meant a trust of which the sketched by the settler, while the details are to be filled up by the good sense of the trustees. The exercise of such a power is imperative, while the mode of its execution is matter of judgment and discretionary. And distinguished from trust with power annexed, a mixture of trust and power is not to be confounded with a common trust to which the power is annexed, for in the former case, as in a trust, to distribute at the discretion of the trustees, they are bound by all events to distribute, and the manner only is left open. But in the latter case, the trust itself is complete, and the power being but an accessory, may be exercised not or may be exercised or not as the trustee may deem it expedient, as where lands are limited to trustees with an authority to grant leases, or stock is transferred to trustees with the power of varying the securities. In case the powers form no integral part of the trust, but is merely collateral and subsidiary, and the execution of it in the absence of fraud cannot be compelled by application to the court. Number 4, trust lawful and unlawful. Again, trust may be divided with reference to the object in view into lawful and unlawful, the former which are directed to some honest purpose, such as to pay dividend or pay debts, etc., which are called by Lord Bacon intents or confidences, and will be administered by the court. The latter are trusts created for the attainment of some and contravening the policy of the law, and therefore not to be sanctioned in the form professing not only justice but equity, as a trust to defraud creditors or to defeat a statute. Such are the designated by Lord Bacon as frauds, covens, and collusions. And 5, the trust, public and private. Another division of trust is into public and private, but public must be understood such as are constituted for the benefit either of the public at large or some considerable portion of it answering a particular description. To this class belong all trusts for charitable purposes, and indeed public trust and charitable trust may be considered in general as synonymous expressions. In private trust, the beneficial interest is vested absolutely in one or more individuals who are, or within a certain time, may be definitely ascertained and to whom, therefore, collectively, unless under some legal disability, it is, or within the allowed limit, to be competent to control, modify, or determine the trust. The duration of the trust of this kind cannot be extended by the will of the settlor beyond the bounds of legal limitation. It is a life for lives being with an engraftment of 21 years. A public or charitable trust, on the other hand, has for its objects the members of an uncertain and fluctuating body, and the trust itself is of a permanent and indefinite character and is not confined within the limits prescribed to a settlement upon a private trust. And that was a short section. Did anybody do any research on a discretionary trust and trying to tie that in? There on page 16 for special trust.
Hello? Hello?
Yes. Hello?
Yeah. I did some research on power of appointment.
Okay.
And it was saying that when an agent, for example, this was from the book Agency and Trusts, when an agent is given the power of appointment, he holds sort of a trustee position and yet is under no enforceable means to administer the trust, although he has to look at it periodically. And it stated that it was separate from a discretionary trust. So what I understood by it was that because it was in a donor-donee relationship, so if the grantor-settlor gives the power of appointment to an agent, who then acts as trustee until such time as the res or the details of the trust shall be given to a trustee, and the agent is under no enforceable obligation to forward such instruction, because it then becomes at his discretion. And the point of interest was that it specifically stated that it was outside of discretionary trusts, but was still within the discretion of the agent.
Okay, so that sounds like kind of like the, say, the U.S. bankruptcy Secretary of Treasury having discretion because he didn't really have any instructions from the indenture. Is that what it's basically saying?
Yep. Even if he did have instructions or not, he still got discretion as to whether to forward the instruction an appointed trustee. So the beneficiary may not actually receive anything from the trustee because there's been no trustee appointed.
No trustee appointed.
Yeah, it's just an agent who's acting. So the scenario I sort of set up in my mind will be if Aunt Mabel gives a solicitor agency for power of appointment, and the attorney, he's looking around for the trustee who can handle the the interest within the trust. He can't seem to find anyone who he thinks fit to administer the thing, so he keeps hold of it until such time as a competent along, and that's at his discretion by power of appointment in a donor-donee relationship.
So was an actual trust formed? Was there actual trust transferred to the agent, or is it still held like in a resulting trust in the grantor or the settler?
I think the instruction is given to the donee.
Oh, so it would be given to the agent then?
Yep.
Although he's not the real trustee, he's just an agent who's going to appoint somebody else to be trustee?
Yeah.
It had to do for the fact that the settler never did express exactly what his will was or his purpose.
It sounds like he was lacking a trustee, so he's appointed an agent.
Interesting. And that's out of the book there, that 54-page book, that 50-page?
Yeah, it was out of there, and it was out of another book that I found called Law of Trusts and Equitable Obligations. I'm just looking for the... because they set up a diagram whereby it shows the donor-donee relationship, and then the sort of like the trust is in a bubble which is separate from the agent, and the agent basically has all the power of the trust, and I think it was under power of appointment. I'm just looking now.
Anybody else have a comment or Eric or Daisy or Rhonda? Any other comments? Press *6 to unmute and *6 again to mute back out.
Christian?
Yeah, Rhonda.
What are we trying to decipher exactly who the trustee is?
Yeah, by Peter's example there from that book, he was, from what he just kind of described, I don't comment on anything about it, yeah. It's like he was the agent, was the temporary trustee until he could appoint somebody else to be trustee. But I was kind of like liking it to maybe the U.S. bankruptcy trustee, say Paulson or Geithner, maybe functioning as an agent, maybe because we haven't done the trustee duty. So I was thinking before, he might be a co-trustee because we've fallen down into incompetence because we're not administering the trust as we should as trustees, even though we appointed ourselves trustee by the 1040 forms.
If we're co-trustees and it's a discretionary trust, and it's at the discretion of the trustee of whether or not to pay the beneficiary because the beneficiary is insolvent. As co-trustees, say we decide to do that because in the end we're the creditors, right?
Right.
So say we decide to do that and we use our discretion to go ahead and pay it and send it to our co-trustee. Does he have discretion to overrule our payment?
Well, I think maybe if we fulfilled the purpose of why there's a discretionary trust, maybe then that would take and unlock the discretionary trust and free up the disbursement and have the trustee, since he's now competent, since he's going to make the beneficiary solvent again. I think you would probably gain access to the funds to be able to do that.
So just to go ahead and pay all liabilities that I may have incurred, and I suppose I could possibly even forgive the public debt, couldn't I?
I don't know if we could forgive it, but I'm certain we could probably pay it.
Well, the public debt is what the public owes me, right? As a grantor to the public,
who owes what to who?
Yeah. So I'm saying the public debt, since they've been using our credit, the public is indebted to the people. Is that right?
Right. Yeah.
Okay, so as the people, do I have, because Scripture, tries to teach me to forgive.
Right.
And, and if I'm wanting this, if I'm part of, his child, then I would want to act the best way. Maybe it wouldn't hurt to put both things in there, that because me as a woman, as a child of the Creator, I don't see that I have any debts. I couldn't possibly pay any debts if I had them. That's why they was paid for me.
Right.
So.
Now you're talking about the public, though, and
So I could forgive. I could pay all. I could offer to pay all liabilities paid that they thought needed to be paid. I could provide a private credit for that, special deposit for that, and forgive everything else. So they could do with it what they wanted to. They could take forgiveness where they wanted to, and I would offer what I had to take care of the rest.
Yeah, I don't know if forgiveness is available in the public realm for fiction.
Well, if I don't forgive them, they're going to have to pay me back.
But really, who are you forgiving in the public realm?
My mirror image.
Yeah. A picture is not sent here, so it doesn't have any forgiveness available to it.
Okay, good point.
We're forgiving our brothers and sisters, right?
Yeah, the real. Yeah.
I'm not sure if everybody knows, but wasn't Patrick Devine using the 1099-C to kind of do that, to forgive the government of, to pay our debt, supposedly our portion of the debt with the government?
Yeah, I think he was. Yeah.
I found the section in the book, if you'd like to hear it.
Okay, go ahead, Pete. Yeah.
Yep. It's duties of the donee of a bare power of appointment. No duty to exercise the power. The donee of a power of appointment is under no duty to exercise the power and make appointments in favour of the potential objects. He has complete discretion, and the court will not compel him to exercise the power, nor even to consider periodically whether he should exercise the power. If he fails to make any appointments at all, he is not in breach of any duty owed either to the donor of the power or to the potential objects, and they have no cause for complaint against him. And then goes on to say in a different section that...
Patrick, read that again.
Okay. So it's duties of the donee of a bare power of appointment. No duty to exercise the power. The donee of a bare power of appointment is under no duty to exercise the power and make appointments in favour of the potential objects. He has complete discretion, and the court will not compel him to exercise the power, nor even to consider periodically whether he should exercise the power. If he fails to make any appointments at all, he is not in breach of any duty owed either to the donor of the power or to the potential objects, and they have no cause for complaint against him.
Sounds like this was really not formed so the court couldn't enforce equity, and really it's between the say grantor and the grantee, or the donor and donee, and that contract was for a future trust to be formed, but he was under no discretion to use his own discretion whether or not he wanted to appoint. So he would be probably brought up maybe on contract law for a breach of contract, maybe because he didn't form the trust. We're in a court of equity, the equity side of the court where trust operates. Since there was no trust formed, there would be no trust for the court to even enforce on.
Okay, so Geithner, he might have been appointed by the U.S., so he has a duty to them because that's what they hired him for. So he's noticed that he's a trustee for them, but we need a trustee for us. Is that basically it? So once we put him on notice and form a trust with him to make that appointment?
I think that, the Geithner was a co-trustee because we didn't do our duty and we fell into incompetency, so the court construed some temporary trustee to be the trustee over the trust and for discretionary trust. But what Pete brought up there, I thought maybe it might be might be acting as an agent. But if there was really no trust res transferred then to the trustee, then there really be no trust, and we're really talking about I think there's a contract. That would be one of the four methods of formation, that last one, number 4, which would be a contract to be formed in a trust in the future. I think
Section 2, mate.
Sorry. He has the appointment to do what we've contracted with him to do, and as far as our trust is concerned.
You mean Geithner?
Yeah. Or whoever.
Well, Section 2 follows that, what you're saying. It says, no duty to consider the width of the field. If the donee or agent of the power does decide to exercise it, he has no duty to survey and consider the range of potential objects of the power before exercising his discretion in favour of any one object. He may appoint to whomsoever he wishes, provided they are within the class, without having to take account of others' benefit if he were to exercise his discretion in their favour. If he is within the scope of the power, the donee may appoint the fund entirely to himself, without even considering the other potential objects. In an exercise of a special power of appointment by the donee in favour of himself, where he has an object, was upheld. In the case of fiduciary powers considered below, the donee of the power does have a duty to survey the range of potential objects before exercising his discretion.
That sounds similar to a section we went over not too long ago in Gilbert's, though, really. Talked similar about the same thing.
Well, it seems to me, this is Michael, it seems to me that we express the trust like we all want to do, and we want to disperse the funds or pay off the debt. But if we pay off the debt completely, that's going to cause a problem with the masses. They're going to freak out. So what if we redo the trust res and add to the original by, you mentioned it before, where we would go in with the not allotment, but the paper that's added to the trust when we send it into Miss Rios, and we add to the trust. So we're basically saying, we're putting more information there. We would say, this is contingent. If anyone else wants to get into this trust and dissolve it, they have to reimburse us first. So we would become the head trustee. They would still go through Miss Rios, but then she would forward it to us and then reimburse. Once these people understand what their purpose is, then we release it. Follow what I'm saying? We become head trustees.
Okay, so everybody's a trustee with a bunch of other co-trustees then. And
right.
They don't really have trusteeship until they become knowing what they're doing?
Right, because basically in other words, it ends up being a board. Like, say, all the people that are on this call end up signing on that document. Like you said, that we all sign together when we send in the Declaration of Independence as the master trust. And then we put on that allotment or the paper added to it, new conditions to the trust, because they did the exact same thing in 1933. So what makes them any different than us?
Well, this next section might throw some light on that.
Okay, go ahead.
This is, besides the power, since the power of appointment is purely discretionary in nature, a donee is under no obligation to exercise it, and the objects have no right to the fund unless it is appointed to them. If the power is not exercised, the fund passes to those entitled in default. Usually this will occur where a donee has been granted the power but has died without making any valid appointments, either inter vivos or by will. The persons entitled in default may be specified by the donor in the terms of the power. If no such persons are identified, the general principles of succession or resulting trusts will determine who is entitled. In some circumstances, the courts have been willing to imply that the objects themselves are entitled to the fund in default of appointment because there was a general intention on the part of that the objects should benefit. And then it goes on to talk about various reasons for default.
What's some of the reasons?
One is express gift over in default of appointment. The power of appointment may itself contain an express stipulation of who is to receive the fund if no appointments are made. Such an express provision will determine how the fund should be distributed. Shall I read that again?
Yes, because that's basically what I just said. If they don't step up to the plate and start getting understanding, then they don't get disbursement of the funds.
Mm-hmm. Which is kind of like tying it back in with the discretionary trust. Their rationale was that this was a better way of doing things. The protective trust on page 140 of Gilbert's, where it says that protective trust may be intended to reach a result somewhat comparable to, and in fact more secure than, the result of the spendthrift trust, but it is logically less objectionable in that the beneficiary can be sure of receiving substantial trust benefits only as long as he keeps his debts paid. So he has to come under the knowledge and understanding he has to keep his debts paid.
Because my feeling is that, I know you mentioned before that you wanted to dissolve the trust and then make a new trust for your account. But to me, if we dissolve the trust, first of all, it's a master trust. We can't dissolve it. Only thing we can do is move the funds around to get paid and then take control at that point in time. Take it away from the U.S. government or the Secretary of State. And at that point in time, we become the trustees and they're our servants. We tell them what to do and how to do it because we've taken control of the master trust. And I think this is what's going on, is that we haven't taken control, as you said earlier, in your teachings.
Right. Now, we could close out our portion of the trust. What you're saying is that it's one big master trust or one big pool with everybody having a share in it. But if I could close out my share and put my share of the remainder in a new trust that I would form, then I would be solely in control of that all by myself.
I don't know if we can do that, though, because thing is, it's a master trust. I know that we have a bunch of little trusts. Each one of us, have our own little trust in there. But how do we identify that? Because we can't.
Hello, we lost you.
You there?
Hello.
Go ahead. Go ahead.
There's a table here. It kind of outlines, the scenarios, what can happen. So it says, has there been a default of appointment? And then it says, for example, yes. Is there an express default provision? And under yes, the property passes under the default provision. And under no, is there a general intention in the favour of the class of objects? And if the answer is yes to that, property divided amongst class. A case in England is Borough v. Philcox. And if the answer is no, are there residuary legatees under the owner's will? If the answer is yes, the property passes to the residuary legatees. If the answer is no, property passes to those entitled under the owner's intestacy, which ultimately can be the Crown, as far as I can find.
Kind of like Escheat. He's in by his Crown.
Yep.
Because there was no heirs to take up the disbursement.
Then it reverts back to the Crown, which is basically the United States government.
Yep.
You know, you mentioned, earlier, and I got cut off, and I wanted to respond to it, where you said where we close down our portion of the trust. I don't think we can do that. The reason being is it's a master trust, because the only way that we can identify ourselves, from what my understanding is, correct me if I'm wrong, is through the birth certificate, and that you can't do that.
Okay, let's maybe clarify that. Maybe we couldn't close down the whole trust as a whole, but maybe I could withdraw my share of the funds in there and form another trust.
But the question is how do you determine what your share is? Our share.
I'd have to go by what the IRS says. Is in the trust fund that's allocated towards me.
Well, that could be in this section, which is an implied trust in default. Which is,
are they looking at it, the trustee is the trust? Is that how they're looking at it? Under the application of the IRS, under that page 3 of the BEN instructions, there were talks about the beneficial owner, and that second paragraph, 4 different examples of different types of trust, and beneficial owners on the one group was the foreign partnership, and the beneficial owners of the next one was the beneficiaries of the trust, and the beneficial owners of the foreign grantor trust were those owned by the grantor, and then the last one was the beneficial owners of the foreign complex trust was the trust itself, and that's where I assumed that the trust itself would have to be the trustees. So is the beneficial owner the trust or the trustees? Is that how they're looking at it? Because that would be a foreign complex trust under IRS definitions then.
Where on page 3 are you looking at this?
Page 3, first definitions, right under beneficial owner in the second paragraph. It starts out foreign partnerships, and it describes the 4 basic types of beneficial owners, which says the foreign partnership, foreign simple trust, and foreign grantor trust are not the beneficial owners of income paid for the partnership or trust. The beneficial owners of the income paid to a foreign partnership are generally the partners in the partnership, provided that the partner is not itself a partnership, foreign simple, or grantor trust, nominee or other agent. So, about agent again. The beneficial owners of the income paid to the foreign simple trust now, that is the foreign trust that is described in section 651A, are generally the beneficiaries of the trust. If the beneficiary partnership, foreign simple, or grantor trust, nominee or other agent. And then the beneficial owners of the foreign grantor trust, that is a foreign trust to the extent that all or a portion of the income of the trust is treated as owned by the grantor or another person under section 671 through 679, are the persons treated as the owners of the trust. And the last one is the beneficial owners of the income paid to a foreign complex trust, that is a foreign trust that is not a foreign simple trust or a foreign grantor trust is the trust itself. And that's where I assume the trust itself had to have a trustee. So really what they were talking about was really the trustee. So there's our three designators of the trust. We're designating the beneficiaries, we're designating the trustee, and we're designating the grantors in 4 examples here. And the other one was the partnerships. So they're tying in and defining who the trust is that they're calling, whether it's owned by the beneficial owner is the trustee, or the beneficial owner is the grantor, or the beneficial owner is the beneficiary, or the beneficial owner is the partnership. And that's what they're using to plug in on block 3 of the form. So Pete, what were you reading there again?
An implied trust in default, which would sound like the Declaration of Independence. In some circumstances, even though no appointment has been made, the court may hold that the funds should be divided amongst the objects rather than particular legatees or by resulting trust. This will only be possible if the courts can find that there was a general intention by the donee of the power to benefit a class. The leading case is Burra, spelled B-U-R-R-O-U-G-H, the Philcox. John Walton granted his surviving daughter, Anne, a power of appointment over his property in favour of his nephews and nieces. The power contained no express gift over in default, and Anne died without making any appointments. Under the rules of succession, the testator's next of kin would be entitled to the funds. However, Lord Cottenham held that the effect of the arrangement was to create a trust in favour of the nephews and nieces subject to Anne's power of selection. When Anne died, without having made any appointments, they each took an equal share in the fund. The principle was stated by Lord Cottenham, where there appears a general intention in favour of a class, and a particular intention in favour of individuals of a class to be selected by another person, and the particular intention fails, from that selection not being made, the court will carry into effect the general intention in favour of the class. The key element is the finding of a general intention in favour of the class. In effect, the court is concluding from the circumstances of the creation of the power that if it has not been exercised, the donor would have wanted the fund to go to the objects. In this sense, the operation of the implied trust in default is somewhat similar to an application where a charitable gift has failed initially on the grounds that the donor had an overriding charitable intention. And then it goes on talking about demonstrating a general intention. The juridical nature of the implied trust in default. There remains confusion as to the basis under which the fund subject to a power is distributed to the objects under the rule in Burra v. Philcox. One analysis is that the power is in fact a discretionary trust under which the donee is under an obligation to make an appointment. Thus, in Burra v. Philcox, Lord Cottenham cited the dictum of Lord Eldon in Brown v. Higgs, that the power is given so as to make it the duty of the donee to exercise it, and in such case the court will not permit the objects of the power to suffer by the negligence or conduct of the donee, but fastens upon the property a trust for their benefit. Similarly,
read that last paragraph, that last sentence again.
Okay. Thus, in Burra v. Philcox, Lord Cottenham cited the dictum of Lord Eldon in Brown v. Higgs that the power is given so as to make it the duty of the donee to exercise it, and, in such case, the court will not permit the objects of the power to suffer by the negligence or conduct of the donee, but fastens upon the property a trust.
That sounds like what you first stated at the beginning there, that the trust was not really formed, but yet the trustee would not suffer because really the trust was not formed, and he had no duty to perform the trust because he had a discretion, because nobody had been appointed, the trust hadn't been transferred, no trust had been formed. Is that what you get out of it?
Yeah, I seem to.
So the master trust is there, but we haven't formed the new trust or appoint someone to disperse the funds.
Yeah, I think the way they look at it is really we're the ones that's supposed to be dispersing the funds, and we're looking, asking everybody in a court case, give me a statement of accounting, and they're looking at us as the trustees and said, you're supposed to be asking yourself for a statement of accounting. You're supposed to know. You're the trustee. And since we never expressed it to be any different, the court never gives us a statement for closure and settlement because really they don't have to. They're not trustees.
So in other words, we have to keep our own accounting so we know what everything is, but how do we know what the accounting is if they don't give us the paperwork? So it's like a catch-22 right now.
Yeah, we never asked. We never asked, although we had the duty.
What's it say there in the 1888 treaties on trust is that a king shouldn't be administering their own trust. Is that right?
Yeah, he's not supposed to be violating the character as Lord. If he was acting as trustee over the subject.
You got servants for that, right?
Well, I don't know whether that would be kind of classified as being somebody different other than him, because there'd be agents of principle. They would be still acting for him, so it would still be like that the Lord was still over them. So I think it would still be violating the character.
Now,
I think if he appointed an agent to be working with him to do his bidding, so to speak, and then it would be nothing more than an agency there, and it would really be the Lord who was still over top of the subject. That would still be in violation of it.
That would still be in violation of what'd you say?
His character.
It would be in violation of his character to have his servants administer his trust?
I would think so, because he'd be like agent to principal, principal to agent.
And that's why the Queen of England is no longer in control of the court.
She has, would you believe, special powers.
What did I just get done reading here? Special trusts?
Sounds... Yeah.
Do you raise things and levitate things?
She's a witch, all right.
I think it's more that she has like overriding power in times of emergency or other. That's what I've read.
So on page 2 it said the confidence in a person, that section. Confidence in a person So for want of the requisite of a personal confidence, it was ruled that a corporation could not stand seized to a use, for it was said that could a corporation be capable of confidence when it had no soul? Nor was it competent for the king to sustain the character of trustee, for it was thought inconsistent with his high prerogative that he should be made responsible to his own subject for the due administration of the estate. And originally the trustee himself, and could not be sued against either his heirs or his sign, for the confidence was declared to be personal and not to accompany the devolution of the property. And it goes on.
That term, high prerogative, I would term that as royal prerogative. Whereby, yeah.
And I think that's section. Page 3 also, where it says, for so the lord who was in by his cheat, a deceiver, a baiter, and intruder, were not amenable to the subpoena for the first claim by title paramount to the creation of the use of the trust. So go ahead, Pete. I just need to step on you there.
No, it's fine. It was just that the royal prerogative, the written, is classed as giving the sovereign, who is apparently the Queen, eminent domain.
Mm-hmm. So who was it that gave her eminent domain?
The Pope.
Some other high man is supposed to be lord over somebody else, huh?
Well, the Pope says he owns the world.
But remember that the Queen's in protestation to that.
Well, didn't James the First basically give it all to the Pope to be absolved for his transgressions?
King John.
I think it just prior to the Magna Carta, whoever that was, like 1210 or something.
King John.
Yeah, maybe.
Yeah. He was only. He's a bit of a suspicious character, really, because he sort of claimed the throne while Richard was kidnapped, whereas Richard had actually given the land in trust to another guy. It was just that because Richard couldn't return because he was being held by the Germans, King John took the throne.
So King John was the de facto, while the de jure was being held by the Haitians or the Hessians, whatever, the Germans. Yeah.
And even that's even more suspicious because Richard, in his 10 years as reign as king, only spent 7 months in England, and he charged or at least the British or the English were charged 100,000 florins to pay for his rule. And he came home for 7 months and was never seen again.
I actually heard the genealogy now traces the House of Windsor, Queen Elizabeth's dad, right, back to Germany, actually, the House of Windsor.
Sure, United Kingdom is the House of Hanover. That's what I was saying to Christian last week. They are sort of like the feudal lords, if you like. And should we be dealing with them direct? And as Christian says, rightly so, is no.
Well, I was thinking, how about since the Declaration of Independence in 1776, my question would be, did it not cut off all other claims to this country?
And men as well, I would say. And women alike.
Yeah, but when England lost the war, and then when Benjamin Franklin went over there to do the treaty, they converted it back to the Queen, and that's why the Queen has part ownership of the Social Security right now. She has control of it.
For the debt, yeah.
No, the Social Security here in the U.S. She's under contract. That's her. It goes directly into Bank of Coots.
So if we settled the commercial debt of the war that was owed, then this country should be free.
But do we want to do that? Because the masses would freak out. They're children that have no understanding. And this is why I was maybe adding to the Declaration of Independence with our signatures and an addendum, is that we hold it in trust until these people have understanding, and then we release it to them. In other words, we're taking control away from the U.S. Inc. as being the trustees.
Right. And that's probably the way it should be, because we should be administering the government. As long as we are sentient and have knowledge and understanding.
Unmuted.
Operating as fiction. It's our really duty, since we know and understand those who, so that they can be free by the truth also.
True, and the information that Pete just read is very interesting, because it's talking about classes of people and everything else. It was very interesting. Great research, Pete.
Christian, if you look at support trust on page 140, section 499, in keeping what we were talking about, the masses, couldn't we form or convert their trust into support trust, which are for the education and maintenance of the beneficiaries?
Yeah.
So, is the Constitution a trust?
Yes.
Okay, so you had the Declaration of Independence, you had the Articles of Confederation, the Declaration of Independence, and there's some question about whether, trustees were set out, in that document. Could it have been that then along came, the Constitution, which did set out the trustees in the Articles?
Here's what one gentleman has to say about that. What I use to support the trust res is the preamble, the Articles of Confederation, and the Declaration of Independence. Memorandums of the true trust which satisfies the states of frauds. Those memorandums define and describe the trust res sufficiently enough for me. The law has always fallen back on the Articles of Confederation in order to find the intent of the Founding Fathers. It is the Articles of Confederation that created the sovereign states, not the Constitution. It is the Articles of Confederation that created free inhabitants of the sovereign states, not the Constitution. It is the Articles of Confederation that created the Union, not the Constitution. The Articles of Confederation are in full force and effect. It is the Magna Carta of England, 1215, from whence we our birthrights, restated in the preamble of the Constitution for the United States of America.
So did the Articles of Confederation lay out trustees?
Well, I think the trustees, that Constitution was for the Constitution. Basically, probably the trustees that were temporarily appointed because everybody fell asleep, wasn't doing the trustee duties.
This guy says it's the preamble of the Constitution. I think just like you did, Christian, that gives us, that lays out the trust.
You mean the Declaration of Independence, you mean?
Yeah. He says, let me see, I'm trying to find it here. If you guys want to, well, I'll give this to you where I found this, because I think this is the email I was telling stuff. It seems a lot easier to follow him because he's specifically talking about, our papers, the Articles of Confederation, the Constitution, the Declaration of Independence. It seems like it hits home a little more, and it's a little easier to follow than some of this, stuff that's worded in Old English. And I found this at thelastoutpost.com, and it's called Our Legacy. And it's, he reiterates a lot of the same stuff that you had said, have told us.
Well, that's from Bernice Beekman, I think is her name. Constitution is a trust. But
right.
If I get what you're saying, Christian, you're saying the Constitution came along and had to appoint trustees because the people fell down on the job. Is that right?
Right. Mm-hmm.
So if
the Constitution is constitutors, and we spelled out duties that they were supposed to do, and they've been going under those guidelines, that they've been.
So the representatives are co-trustees,
which are basically people in Congress and all those people, and that's why I'm saying is go back and do the addendum to the Declaration of Independence, and then reinstitute everything. Now, I know a lot of people want to bring back the Republic, but the Republic is a dead fish. It's something that you got to, and this is where I don't want to get into Scripture, but Scripture does say that it goes on and beyond that. So in other words, we're looking for the new kingdom, and this is a crucial point right here, where we merge Scripture and the Declaration of Independence together and go on to something bigger and better. Otherwise, we're just rehashing old news. It's the same problems are going to occur again. That's why the temple was done away with. That's why the priesthood was done away with, because it was a failed a process. And what we're dealing with right now, Kristen said. You there?
Did we lose?
You there?
Yeah, we're here.
Yeah.
Go ahead.
Where we're going to merge Scripture in our Father's kingdom and bring in the new millennium or the new kingdom, because we can't go back.
Somebody doesn't like us.
Huh?
Somebody doesn't like your phone that you keep cutting out on us.
Oh, okay. Is that better? Is that better?
Sound good there.
Okay. Well, I'll quit hitting the button then. I'm holding it up. Look what we've come up to the point. This is what they've destroyed it. We have to go to the new millennium, the new beginning, merging Scripture and the Declaration of Independence, because the Declaration of Independence comes derived directly out of Scripture. Right. So we're bringing in our Father's kingdom, and I don't want to push it too hard, but this is what I'm seeing. I mean, just like the priesthood was done away with because it didn't work. And just like, we're children that are growing, and I'm talking about a nation as a whole or the world as a whole, and now we're coming to the next threshold to bring in the new millennium, or not the new millennium, or the new teachings of the truth. And this is where...
A higher.
I agree with you. And, I see it all around us. And if we reinstitute that, all it's going to do is postpone it for another 1,000 years or 200 years or whatever, and the same thing's going to occur again. This is where we have to merge the two trusts together.
You're cutting out again.
Okay, Scripture and the Declaration of Independence.
I found the section I was looking for with its powers of appointment and redistribution.
Redistribution?
Yeah.
So not distribution, redistribution.
Yeah.
Okay.
That's because they already distributed to themselves once.
It says the nature of powers of appointment. Powers of appointment are one of the equitable mechanisms which facilitate the management and allocation of property. The key feature of a power of appointment is that it is discretionary in character, unlike a fixed trust or a discretionary trust. The donee of a power is under no enforceable obligation to make any appointments of the fund at all. Even if the donee were never to make any appointments at all, he would not be in breach of a duty owed either to the donor or to the potential objects of the power. The court will not step in to compel the exercise of the power, but it will exercise a supervisory jurisdiction to ensure that, if the donee does decide to exercise the power, he does so properly. Powers of appointment are a common mechanism to determine the allocation of the surplus remaining of a trust fund after the beneficiaries have received their defined interests. Many older cases concern family trusts where the property of a testator was left on trust for a spouse for life, with a power of appointment granted over the remainder interest. This allows the donee of the power to decide how the capital of the fund should be allocated on the death of the life tenant. The discretionary nature of the power means that the testator does not have to predetermine how the remainder interest should be distributed, and allows the donee to take account of changing circumstances between the death of the testator and the death of the life tenant. The more recent cases have tended to concern pension funds where the donee is given a power of appointment over any after the contributors have received their contractual entitlements. The successful investment of many pension funds has meant that their assets exceed their liabilities, so that there is a resulting surplus. The power to allocate the surplus by exercise of a power of appointment, whether to the pensioners or the company, is therefore an extremely valuable right. And then it gives an example of powers of appointment whereby the legal title is held by Mrs. Slade. She gives the will to the trustee, and then he has the discretion as to whether to disperse it to the equitable owners, and in this case it's a Mr. Slade, who is the life tenant, and to be selected by Mr. Slade is the objects of power, the Slade children. And then it goes on about classes of appointment.
This is talking directly of superseding the Declaration of Independence, if you really look at it, and bringing in the new millennium, or the higher level. I don't know if anyone else sees that.
Well,
Yeah,
who has the right to force the appointment? Does the beneficiary have the right? Does this specify anything like that for enforcement?
I'll have a little read and see if I come up with anything. It says, classification of powers of appointment. Though all powers of appointment share their discretionary character, several subcategories of power can be identified which are differentiated by the nature of the class objects and by the exact duties of the donee. So A, classification by the nature of the class of objects. There are three types of power of appointment: general, special, and hybrid powers. They are differentiated by the range of potential objects in whose favour the power may be exercised. So under general powers, under a general power of appointment, the donee enjoys the right to allocate the property by appointment to anyone he wishes. The donee may even appoint the property to himself. This extremely wide power is tantamount to absolute ownership by the donee. Then special powers, where the donor of a power has specified that it should only be exercised in favour of a class of people, it is said to be a special power. The donee has absolute discretion whether to make any appointments of the property, but any must be made to persons within the specified class. In Weeks' settlement, which is 1897, doesn't really give a case. Mrs. Slade granted the life interest of her estate to her husband and gave him a power of appointment over the reversionary interest in favour of their children. This created a special power in favour of the class of their 8 surviving children. Mr. Slade had discretion whether to make appointments at all, but he could only make appointments to those who fell within the class of potential objects. And from what we read earlier, he could choose children which he deemed fit. Similarly, in Gestetner settlement, a power of appointment was granted by Sigmund Gestetner in favour of a class including persons, the descendants of his father and uncle, 5 charitable bodies, and the employees or former employees of Gestetner Limited. In a case called Sayer, a power was granted in favour of the employees, ex-employees, and their widows and infant children of Sayers confectioners. And then the last one is the hybrid powers. A hybrid or intermediate power is the inverse of a special power. The donee is entitled to make appointments in favour of anyone except the members of a specified class. In Re Byron settlement, which is again 1891, a power of appointment was given by the testatrix to her daughter in favour of anyone except her present husband or any friend or relative of his. In Re Lawrence Wills Trusts, which was 1972, Mr. Lawrence granted his wife a power of appointment over his residuary estate in favour of anyone except her relatives. I could go on.
Hey, Christian.
Yeah, Rhonda, go ahead.
Who do you think administers the Queen's Trust?
I don't know. I haven't given much thought.
Well, the house that she's under, the House of Windsor, which is under the House of Saxe-Gotha-Coburg, is under another 2 houses. You can browse them on the internet. But the ultimate one seems to be the House of Wettin, which is Wettin. So it could be they are the trustees for the Queen.
I'm wondering if they're related to von Braun, that basically is the head guy of the Federal Reserve out of Germany.
The BIS?
The IRS, yeah. He's the head guy. He's the one that controls everything. And he's out of Germany. I wonder if they're related. Probably are.
Well, Germany's a funny little...
Well, wouldn't it stand to reason that if the Queen, she got here just like you and I did. She's no better or no worse than anybody here on this phone call. That, and since some have taken it upon themselves to take control of the resources that our father gave us, it would probably stand to reason that her trustees would be our trustees.
Yeah, but don't they consider themselves to be lords and above everything else?
Well, I can call myself queen too. You know, she got here just like I did. You know, she has.
Well, you know, power or authority has to be given, but as long as everybody is giving these people authority, then they're going to be in power. Because really they have, like you said, they have no more rights than anybody else, except we're the ones that are deifying them as lords and over everything. But when we stop exercising the power, giving them by the authority that we give them, then they cease to exist.
We've acquiesced that authority to them because they were, if you trace back that family, it goes all the way back to Israel. And because the queen sits on the stone, I forgot the name of that stone when she was put into office or in her place. But that stone was brought over from Israel, and they are direct descendants of the tribes of Israel. And relinquish that power to them. Now we're coming to the point where we're understanding who we are, so we could stand up and stand shoulder to shoulder with them now. It's just that we have to express ourselves through the trust that we know what we're doing, because they've basically been watching over us like little children.
Yes, right.
She sits on the...
paramount to the title to creation of the use of the trust.
Say
like
again?
Page 3. On page 3 of the treatise, it says that they're claiming, the Lord is claiming the first claim by title, and that title is paramount to the creation of the trust or the use. But then back on the other page, page 2, then again, so they don't really have the right.
They have the right if we give it to them.
That's right. That's what I was saying. They're claiming heirship because we were giving them the authority, and that's why they have the power.
Well, yeah, I agree with you, because thing is, you got to remember, Samuel, we wanted a king, or Israel wanted a king, and the Creator said no, and they went against him, and now, you have to suffer the consequences of your kings and queens. It goes that far back.
Yes, these are under the section of privity of estate and the privity as regards to the city key trust. So privity is knowledge, having knowledge. And it all comes back down to what I've been talking about, that really to be a fiction is to not have the knowledge or understanding. And if you don't have the knowledge or understanding, you're a fiction. If you have knowledge and understanding, you're sent here and you're the real life man or woman.
That's why I think for me, having the real life knowledge, the sentier knowledge, is knowing my relationship with the Creator, and that that we all are heirs of the Creator. That's the main title. I've even thought about, how they say two witnesses. You have two witnesses. I've even thought about with the documents to send in is to get two witnesses, because the main title that I'm going to express is that relationship with the Creator and the Savior, because that's the main one, and to get two witnesses, expression of that, and send that in with the documents. They're heirs just like we are, and they can. I don't, but somehow, that she don't sit down and write checks, and Prince Charles, when he's out on his yacht getting fresh vegetables flown in every day so he can eat properly, he ain't worried about adjusting the books.
No, he has it done for him.
They're the chief bankers right now. They're the ones that are running the show. And they've got their servants underneath them. There's no difference than us of hiring people and having people work for us, but it's initially of expressing the trust, as Christian's been teaching us. We have to move the title, and then we merge the titles to the main trust, which is, of course, Scripture. And this is where coming into understanding of being able to look at someone when they come in and say, hey, I want to get into my master trust, and basically testing them. And if they pass the test, then okay, go ahead and you can get into your trust. But if you mess up and you start acting as a debit creditor, it's going to be taken away from you.
That was one of the points that Christian was hitting on earlier. Was it that you mentioned something about a contract, Christian?
The contract to form a trust is always in the future.
Well, I've found here contracts to exercise, which is a contract to exercise a power of appointment will operate in equity as a valid exercise of the power, provided that the contract is specifically enforceable. This is an application of the maxim, equity treats as done that which ought to be done. Since a contract to exercise a testamentary power is not specifically enforceable, it does not operate as an effective exercise of the power, and the only remedy available of the disappointed object is an action for damages for breach of contract against the estate.
Right, yeah. Now, is that in equity? You bring the breach of the contract in?
Yep.
What is that?
Yeah, and there's a case that it cites, which is it says Bradshaw of 1902, and it says one chapter.
Trust in equity is making the contract an equitable contract, also forcible in equity. So it wasn't an at-law contract; it was an equity contract tied to a trust, which made it an equitable contract and enforceable in equity also then. That's kind of a good point there. So if we got a breach of an equitable contract to form a trust, then we don't come in under at law, we come in under equity again.
And it says that that's the only remedy available to the disappointed object, which is beneficiary, is an action for damages for breach of contract against the estate. Or it could be an action maybe by the trustee against the agent.
Yeah, but there's what I was thinking. Where I read someplace before where it's if the trust had not formed, then really the trustee or the alleged trustee, since he didn't do an appointment, trust was never formed, and therefore he could take the property for himself because it was he wasn't under any obligation or duty because the trust hadn't formed yet.
Isn't that what the government has just done or has been doing?
Yeah, and I think they may have done that by prescription.
Because
debt, acknowledgement of the debt will invalidate the prescription.
A breach of trust of duty by a trustee is a violation of correlative right of the SETI K trust and gives rise to a liability on the part of the trustee and a correlative cause of action on the part of the beneficiary for any loss to the trust estate. Applicable in respect to both positive acts and omissions or negligence constituting a breach of duty by the trustee. A trustee liable for breach of trust is personal, there goes their immunity, in character with all the consequences and incidents of personal liability and is enforceable against his estate. A trustee breaching his duty comes with the maxim that equity will not aid one who comes into court with unclean hands. So, so that's what we're talking about, this breach. That's how we come after the trustees, right?
Yeah, for enforcement.
And this guy says the repudiation of the trust, the beneficiary must have notice of the repudiation and one, maybe that's not what I wanted to read right there.
Repudiation means that he's been forgiven. No, I don't want to sign a contract of repudiation with the trustee because I want to forgive him I want him to get him to do the duty. Disperse the funds.
Yeah. I lost my place here.
After reading that legacy thing, kind of what I got, what she was trying to, some of the things she was trying to say in that document was that every year that we denounce our trust by, signing these forms that they had to sign.
Right.
And the codicils that we add without without really knowing what we're doing. Because like you said, we've lost our mind when we do those things. But by doing those things, she was pointing out that we was denouncing our trust for that year. And basically saying that, hey, go ahead and do what you want with it because I don't want it.
So here's something that Christian has said a few times paraphrasing Christian here. This guy or woman does. Do you get it? Have you gotten it yet? Has it been brought home to you yet? How long must the message be sent to us? Have the trustees not gone out of their way to have us convey, transfer, contract, or assign our beneficial interest in the res by way of threats? Have you not felt that justice is missing? Justice resides in the trust. Just us resides in the will. And then he says here, in the enforcement of the trust, an action or proceeding to enforce a trust or to enforce the liability of a trustee for breach of trust can be brought only by one who has a qualifying interest in the subject matter. The beneficiary or one in his right is ordinarily the proper party to bring an action to enforce the liabilities of the trustee for breach of trust.
But how can you say they breached the trust when you denounced your rights to it?
Well, I agree. I agree. When we sign it away, we don't really have any place to stand. But once we get on the right side of the trust by saying, by whatever we have to do to sign papers to rescind all of our signatures on those contracts and say, now I am, the grantor and the beneficiary and co-trustee. I guess if we can be all three of those.
I mean, we're the ones that breached the trust. They haven't breached the trust. They've been doing what they were created to do. It's the people that have breached the trust, us, because we have not stepped up to the plate. So it's putting the finger on them is not it. It is us.
Well, yeah, I agree. I agree.
I mean, this is where we come and we express the trust. We do the W-8s. We do the Declaration of Independence and send it up to the Secretary of State, and then turn around and send it up to Miss Rios, expressing what we want her to do. We appoint her on what we want her to do, and then also put an addendum to the Declaration of Independence in case anyone else wants to come in, because what they do, this is my thought, what they
Are you blanked out?
understand.
Say that again.
What they Hello?
Yep, you blanked out again.
Well, I'll try it again. Are you there?
Yep, go ahead.
What they do, okay, these people that come in, say, underneath of us, and if they express the trust and screw it up, it's going to screw it up for the rest of us. This is my thought. I might be wrong. Because if they fall back into debtor creditor, it's going to affect us, because we're the ones that okayed them. Said, okay, you look like you know what you're doing, and it could come back on us.
Well, what this is, the old adage that you knew or should have known will just not work in the case of the trust. How could you have known when there were acts of omission, non-disclosure, lack of understanding of your rights, and when everything you were told was done in order to mislead and deceive you and coerce you into giving up your beneficial interest in the trust? On the other hand, ignorance of the law is no excuse for a 14th Amendment citizen.
Yeah, well, that depends on which kind of law form you're coming from, because under common law, he's absolutely right. But under trust, he's absolutely wrong, because nobody needs to know or understand. And the fact is, if I give you my pen and say I want my pen back, none of us, me included, understood that we were forming a trust.
Right. Technically, I agree with you. No one has to know, but the whole time when people are deceiving you, deceiving...
Nobody has to know that a trust is being formed. So the formation of the trust, nobody really needs to know. But if I was to come to the point of enforcement, now I would have to know. Somebody has to know at that point. So somewhere along the line, somebody does have to know, especially do the enforcement. Because I would have to know and understand that there's a trust in existence for me to enforce a trust. Otherwise, I would be enforcing debtor-creditor.
And they do know, and they don't tell us about it. When have we ever been told that there's a trust?
Well, we have to look how this public world is functioning, and they're not under any obligation to do that. That's just the way the rules go. And then we go in there and we dance on their stage in their realm, and then we expect them to. It's like we go to France and tell France, hey, you guys are doing it all wrong here. You got to do it this way. No, they're in France. They do it their way. And we're trying to impose upon them English ways or American ways, and you just can't do that.
But if it's a government by the people, and I go to my servant and I tell him, I give him an order, and he tells me to go get, go jump in a lake, who's wrong?
Over the people, that's the problem.
Well, that's what I'm saying, because they don't respect me as king, because I am king. But they don't respect
you haven't expressed who you are. If you go to his office and say, this is what I want you to do, he's going to look at you and say, hey, this guy's crazy. You have to prove it by the documents that you put into play. And once you do that,
why do I have to put any paperwork into play? I'm a sentient being. God is my.
Wait. The way to prove things in their realm is they got to be able to see a record. So you have to produce a record for them to see it.
Yeah, but their realm is all fiction. I'm in the truth. They should conform to me, not the other way around. If I tell them that's the way it is, that's the way it is. God, me, then them, because I created the government. And that's where these people got it all wrong. They're our servants, and they think are our masters.
Yeah, I agree with that, but trouble is to get there from point A to point B, you have to go back the other way to come around and get it.
Okay, but you agree, but then you say, no, I should do this. I should capitulate to them. No, we shouldn't capitulate. I should tell them I'm king. This is the way it's going down.
Well,
period.
Wait a minute. Don't you think that when the queen sends out
the way you're talking right now is to bring up arms against them, and that's not what we do not want to do, because they've got more guns than us.
No, I didn't say to get angry and hostile with them, but I'm just saying that they're the ones that need to be educated. That look at, aren't you the servant?
No, they don't, because they've been running the show, because we have acquiesced the authority.
Right.
Yeah, don't you think they gave us clues like the public trust, Social Security trust?
To take the power, we need to act like trustees and take and do the trustee duty so they don't have to.
Okay,
well,
so
even when the queen sends out a decree or whatever, she writes it down and seals it. She don't have no problem writing down an order.
Because everybody recognizes who she is. They don't recognize us yet. So the only way they can recognize us is that we put into play, do their little paperwork. That's the only thing that they recognize. And once it's into play, they cannot refute anything that we're doing. Now, they can turn around and they're going to put up a stone wall because they're going to test us. But if we persist, we will prevail.
Well, I'm not disagreeing with that. I was just trying to make a point that you shouldn't be afraid about writing anything down.
Well, right, but
going to study on ambassadorship. If you do a study in corpus juris secundum on ambassadors, you'll find out that to be going into a foreign country, you must first present your credentials. The country is supposed to grant you an exequatur or a right of passage and qualify your duty that you're going to be doing over there for the time you're supposed to be there.
Okay, so
is our charter to operate in that foreign country, or the recognition for that person, that king, so to speak, or that ambassador to come in and do whatever he's going to do in that country. That's the model we have to follow also.
In other words, we're going into the court, and if you know any of these old movies, they pronounce who you are. And once you're pronounced, you have the floor. Dress the queen or king, and then tell of what we're trying to set up right now. to announce ourselves, who we are, because we've been quiet we've been asleep.
Mm-hmm. And then we need them to recognize us. We have to have the formal recognition, which is the executure, and there's two ways. It says there's a formal recognition and an informal recognition. The formal recognition is when they roll out the red carpets in the bay and they give you a big ceremony and they announce you into the country. Now, the informal way could be just as much as changing your identity and your trust number and coming up with a new passport identity with a name that's the same as yours but with a new number.
That's one thing I wanted to ask you about is this passport. I think that is a crucial thing, and possibly that's where we get our ambassadorship is directly from the Secretary of State, Hillary.
We should be looking into how they've gotten out, and was it just a straight expatriation or what they did, or well, I don't know exactly. Has anybody done any research into the Secretary of State's, how they've gotten out of the system, so to speak?
I'll start researching it and see what I can find out.
The Virginia Bill of Rights, dated June 12, 1776, states in Section 2 that all power is vested in and consequently derived from the people, that magistrates are their trustees and servants, and at all times amenable to them. Here we have explicit mention of the trustees. The amendments of the Constitution were fashioned after this document. Named trustees, but as servants. But they've gotten, I guess it's what you guys are saying. It's been so long that they've been the boss, the unruly brat kid. He doesn't want to step off,
Correct.
He don't want to give up his toy. Well,
now you got the tail wagging the dog.
But he has an obligation to do that, to make sure that we're not, fakes.
Yeah, but the brain was not telling the dog to wag his tail. It was the tail telling the brain where to go. So it comes back down to when we wake up, that's when we have the knowledge and understanding how to operate this trust.
So,
that's why we're on these calls.
Right. So, what do I have to do to get my remedy? When I come up there and tell him I'm king and I'm this and I'm that, aren't they supposed to go, hey, geez, I guess he knows, because at least he's come up to me and said it. What am I
have to have proof that
why do I get?
Or let's say the proof.
Well, I thought the trust. I thought the trust was right there for everybody's eyes. The preamble of the Declaration of Independence, and that's a trust.
But I guess they've turned it into a rite of passage, and everybody has to go through the gauntlet. And those that make it gain the rights, and those that don't, they go back and start over again. It's like Mario Brothers.
Well,
Christian, I got a quick question, a little bit off the subject. I just need a definition. What is an owner trustee?
Owner trustee?
Yeah.
That was one in the Ben, wasn't it?
I don't know if it's in the Ben, but I know some of these banks with these securitized trusts, they use that term owner trust or owner trustee.
I think they're referencing the beneficial owners, just like what it is in the definition on the 8 Ben there, where the IRS is defining who the beneficial owner or who the owner is.
Okay, now who is the owner trustee? So that's a term that they use.
Okay, that would be like this one here, last one, number 4, where the beneficial owner is really the trust itself, which I put the label has to be the trustee. So that would be a foreign complex trust, according to IRS rules.
So you're saying the trustee is also the beneficial owner?
Yeah, because by definition here it says the beneficial owner is on a foreign complex trust is the trust itself. And I thought, that sounds strange. How could the trust itself be owner? And I thought, well, who's over the trust? That's the trustee. So the trustee has to be owner. And that fits.
So you're saying that the owns the legal and equitable title. How is that
Well,
a trust?
Might not own the equitable title, but he owns all the legal property and has all the rights and the say-so in it. Although I was reading something the other day that it looked at these older descriptions of things from this treatise was pointing to the fact that the way they looked at it was really the trustee was not the real owner. They looked at it as the beneficiary being the beneficial owner. So, it's kind of depends which way you want.
Because I'm running into this thing is, I ran across a situation where the trustee is also saying that they're the owner.
Yeah. I think that complies with the IRS, beneficial owner being a foreign complex trust, where it's the trust itself, which would have to be the trustee.
Well, let's say if the grantor dies, isn't the beneficiary the true owner that has legal title, and the trustee just has equitable title?
Oh,
the future,
the other way around.
The beneficiary would have as being the ultimate owner, but sometime in the future.
Yeah,
depends
well,
on the investor,
isn't
he's going to disperse the funds and the legal titles.
Isn't the legal owner? Isn't that paramount above equity? The legal owner?
No, it's beneficial owner.
I mean,
the trustee's legal owner. He has legal title. He has possession and say so on the property. But it's supposed to go for the benefit of the beneficiary, who has the ultimate title, equitable interest, the beneficial title.
Oh, okay. Getting back to my question, is the IRS the only place we can find that definition? Because
I didn't look in Blacks or any place else, but
I couldn't find it.
You can find it
the entity that acts as trustee of the issuer, and a typical owner trust structure called the owner trustee.
Well, I think they're looking at it as the trust got the legal titles. He's got 9/10 of the law possession. Let's classify him as the trustee owner, or the owner trustee.
So are they saying that he has?
Lost you, Harold.
Are they saying that this trustee also has beneficial ownership?
I don't think so, because there wouldn't be a trustee. There wouldn't be any trust, because the titles would be in one entity. Does he have did they mention anything about a co-beneficiary? Unless he's got a co-beneficiary also.
I see nothing for the beneficiary here.
He could, as trustee, have some beneficial rights also as a co-beneficiary. That was expressed in Gilbert's. I forget exactly where it was, but it said something similar, that if the trustee had a co-beneficiary interest, then he would be a co-beneficiary.
Christian?
Really, which way you want to look at it. 9/10 possession, full trustee, legal title and trustee. 1/10 is the beneficial or the beneficiary, the beneficial title. But that 1/10 is more powerful than that 9/10 possession. Because ultimately, the beneficiary can make a claim against the trustee for not making the disbursement.
Well,
and that ties in with these old trustee books, these trust books that says that they look at it as the beneficiary, somewhat one, even though he hasn't gotten the funds yet.
So if Dad owns a car, he has legal title to it, lets his son use the car as the beneficiary or equitable title. You tell me the son has superior, is his 1/10 is superior to his father's 9/10?
Well, no, I don't think so. I think it would be looking at it like the ultimate owner of the car would be the beneficiary, who would be the father, and is letting the son drive the car as trustee and giving him in possession.
Yeah, but the dad is the grantor, the kid's the beneficiary, but the dad's, dad has legal title to it, right? I mean, I don't know how equity can ever, overcome legal.
Well,
that doesn't make any sense.
Because the grantor is setting the law of the case, which way the law is going to be interpreted.
And that was only being a resultant trust anyway, because the DMV was on the vehicle in the legal title.
Right. Yeah. Okay.
Yeah.
But I feel when somebody tells me they have legal title, that tells me that's paramount to equitable title, because
No, that's 9/10 possession. Legal title is trustee.
Yeah, even Black's Knife doesn't have that in there. Just went to Black's Knife and
But the state holds legal title on your car. Is that correct?
Apparently so.
I think they're construing it that they're the beneficiary. I think they have beneficial title.
They have beneficial title, then how can they?
That's the 1/10 title. And you've got possessory title. You got possession of the car. You got 9/10 possessory title. You got the legal title, the certificate of title. The state has beneficial title, which is the real ownership of the car.
So that's why they can tell you what to do with the car.
Yep, that's why they say you got to get insurance, because you don't really own the car. You just got 9/10 possession of it. And you got legal title. You got liability.
You're holding it for their benefit, so you got to keep it up.
Yep.
You got to keep up the property.
Yep.
So
you're a tenant on the land.
So equitable
under a feudal system with a different name on it, although it's still feudal times.
Well, I found evidence of that yesterday.
What's that, Pete?
Bona fide evidence of that yesterday about how the monarchy. Yeah.
Okay, Chris. Okay, go ahead, Pete.
I was just going to say, if I can move just a minute, just to say about the diplomatic rank.
Okay, before we go there, because I'm actually working on something that's why I needed that explanation.
Cool.
So if a bank as a trustee is working under asset-backed security trust, and that trustee says...
Wait. A bank is operating as trustee?
Right.
Like on a mortgage, you mean?
Yeah. One of the securitized asset-backed security trusts.
I don't know if that would fit, because that one case said that, that bankruptcy case said that the payee on the note beneficiary, and that's usually the bank.
Okay, but the bank. But now when they move these into these asset-backed security trusts, title is moved away from the bank into the trust. So now who is the owner?
Yeah, I think in that case nobody knows.
Because they're saying that as trustee that they're the owner and holder of the note. I'm saying you can't be the owner and be trustee.
Yeah, I'll agree with that. They can't be trustee, they can't be owner once they securitized it. And one of the other things was the fact that that case said that the payee on the note, which would be the bank's name on the note, that signifies that they're the beneficiary. And it can't be trustee. And the bank doesn't want to be trustee either. Because if they're trustee, then they merge the title on themselves because they got the beneficial title.
Right. But keep in mind that that bank that was on the initial, that's on the note, the initial so-called lender, at this time is out of the picture.
Yeah, true. Yeah, because it might have switched hands. Once it switched hands, then.
Right. So now it's switched into the asset-backed security trust. Now you have another bank.
Doesn't the status of beneficiary transfer with the note to the next party?
Well, that would be the trust, but then you're talking about a trust that's commingled.
Yeah, yeah. That's my point.
So now how can this bank say that they're the owner?
They just lie.
Yeah, I guess we're allowing them to come in and prove with nothing.
Okay, now I'm going into one of these securitization articles, and they got this list of players, and when they come under trustee, they say it's an entity that acts as trustee of the issuer in a typical owner trust structure called the owner trustee. Now, owner trust structure, that's 100% new to me. Couldn't find nothing on it.
Well, that might be that simple trust. I think it's a simple trust. No, just mention it that way. And a simple trust was on page, where was that at?
20? Was it?
Yeah, somewhere.
In Gilbert's?
No, in the treatise.
Oh, in the treatise, okay.
Yeah, the simple trust is where the property is vested in one person upon trust for another, and the nature of the trust not being prescribed by the settlor is left to the construction of law. So in the case of the City Key Trust, as just habandi, or the right to be put into the actual possession of the property, and justice disputandi, or the right to call upon the trustee to execute conveyance of the legal estate as the City Key Trust directs.
Okay,
so
but the key in that explanation still is for the benefit of another.
Yeah, but does he have duties or? Because the special trust is where he has duties as trustee,
well,
and
his duties would
he
be
has no
in
duties.
the indenture. In an owner-structured trust, the trustee appointed under the indenture created pursuant to the issuer trust agreement.
There's something here on special trusts. The special trust is where the machinery of a trustee is introduced for the execution of some purpose, particularly pointed out, and the trustee is not, as before, a mere passive depository of the estate.
That's
is
the point
called
right there. That's where I was going to next.
Yeah.
The trustee is not, as before, under the simple trust, a mere passive depository of the estate.
Okay, I'm looking at one of these in the SEC website, and they have something here. Owner trustee, with regards to this filing, means Chase Manhattan Bank, Delaware, as owner trustee for certificate holders under the trust agreement and any successors in such capacity.
So apparently it's a trust agreement then. It's setting that up.
In the trust agreement, which they're not going to post that.
Would that be then the contract thing, the contracts to exercise?
Yeah, it could be one of the codicils attached to the indenture, yeah. Like this pooling and servicing agreement.
Yeah, I'm looking at a sample one from Real Deal Docs. Okay, Nissan Auto Receivables 2005 Owner Trust, a Delaware statutory trust, amended and restated trust agreement between Nissan Auto Receivables Corporation 2 as depositor and Wilmington Trust Company as owner trustee.
So apparently they're defining
now
their
as
own
owner
business.
trustee, just in that title, they're the trustee for Nissan Auto Receivables Corporation.
I'll bet you can find out that anybody that does an assignment becomes the trustee for them then, because of the way they got it specified in an indenture.
Okay, let me.
But that's on a new trust though. That's not on the original trust.
No, this is amended. This is amending an existing trust. Amended and restated trust agreement.
Is there a amended time clause in there?
I don't know.
And who amended it?
This is being amended by. Let me get past all the titles and everything.
Great research, Harold.
Roger. Okay, it's between the same parties. So they're actually, I guess they're restating an original trust agreement. Amended and restated trust dated September 1605 between Nissan Auto Receivable Corporation 2, a Delaware corporation as depositor. Now, what do they mean by that term, Christian, as depositor? Are they the grantor?
Read that one again.
Okay. Amended and restated trust agreement dated as of September 16, 2005 between Nissan Auto Receivables Corporation 2, a Delaware corporation, as depositor, and Wilmington Trust Company, a Delaware banking corporation, not in its individual capacity, as owner trustee, amending and restating in its entirety the trust agreement dated as of December 23rd, 2004, in parentheses, the original trust agreement, in parentheses, between the same parties, and herein referred to as the, quote, trust agreement, end quote, or this agreement, end quote.
Sounds like depositor was when they're doing a special deposit as maybe trustee.
Well, that was the first party.
The bank, right?
The first party was the depositor, and the Wilmington Trust Company is the owner trustee.
Okay, so I imagine the depositor would have to be the grantor making a deposit and a special deposit into the bank.
This sounds like what we're going to be with the Miss Rios. Can you forward that information to me, Harold?
Okay, yes.
Is that a digital searchable copy, Harold?
Yeah, let me give you the link.
Well, can you do a search for this phrase, from time to time?
Time to time?
From time to time.
Okay, hold on.
Post it on Skype, Harold, on the conference call, the free conference call.
Okay, give me a second.
On Skype? Where would I see those text messages? Can anybody help me there?
You should be able to go to free conferencing and put that into your contacts. But I haven't seen it yet. I don't know if Harold will be able to put it on the message board.
Yeah, I'm listening via Skype, but I'm just wondering where I would see those text messages in the...
Well, we've got a group going. There's about 100 people in there. If you want to join that group, and you can post it up there, and then about 100 people who are studying what Christian's teaching can benefit from that too.
Okay, the only thing I come up, Christian, with from time to time is once in a while at intervals.
Well, that's probably the same thing, yeah. They usually put some kind of clause in there that modify it from time to time. They'll be sending out modification. And it's, I forget what they call that special clause that they put in there. Addendum clause, is that what it is? I forget.
Hey, Joe.
Okay, what is the Skype setup?
If you add me, it's Cheeky Monkey One, which is CHIKIMONKI, and then the number 1.
Okay, now start that over again, Pete.
CHIKIM for mother, ON for November, KI, and then the number 1.
Okay, by grant or beneficiary, United Kingdom?
Yep, that's me. Yep. And if everyone wants to join that, and then we've got a hub.
Okay, so I got you on there now.
Yeah.
All right, I can send you a link.
United.
Okay, so you can post it up then.
Yep.
You have better access than I do.
Say again, Pete, because you cut it out halfway into the...
CHIKIMONKI, and then the number 1.
Cheeky means kind of fresh, doesn't it?
Yep.
Lock, stock, and 2 smoking barrels. Okay.
Hey, can you guys hear us?
Yeah. Is Eric?
Yeah, loud and clear. Oh, that's why you didn't hear from us all this time. We were muted out. We didn't know.
Press star 6?
Yeah, JG brought us in, and I guess he didn't know, or maybe he didn't hear, or whatever. He was having some technical problems. But hey, back on what you guys were talking about earlier with the trustee, and do you think that maybe Geithner might be trying to serve 2 masters because he's not only the trustee, is he the trustee for the private side and for the public bankruptcy as well?
I don't know. That might be. Could be a breach, some way. Kind of biased.
Because how can he provide us remedy on the private side if he's getting pushed towards the public? Because that's what that's where the real emphasis on his public role is.
Yeah. Looks good one way, but not so good the other way.
And if he's getting pushed that way, is there anybody better that we might want to approach with any of this? If he,
I think we are the ones that really, the ones that's in control. But since we haven't, done our duty as, say, trustee, then they're co-trustee or agent for us. I think it comes back down to, when we get sent here, when we get knowledge and understanding of really who we are as grantor and we're the whole shebang here, then that we're no longer a fiction. Then you don't nanny any longer. And the courts are the nannies. As in the words of the old counselor, the parents of the trust were fraud and fear, and the court of conscience was the nurse. Nurse of the nanny.
Where's that from?
It's at the bottom of page 1 of the Rise and Fall of Progress Trust. On that treatise. On the introduction.
What page?
Page 1 at the bottom.
Okay.
Treatise on long
and
trust.
Stuff. And Peter, you still on the line?
Yeah. Yep, still here.
Peter, you still with us?
Can you hear me?
You were reading. What book were you reading? Yeah, I can hear you. What book were you reading out of, and when was that published?
That was The Law of Trusts and Equitable Obligations, 4th edition, by Pierce and Stevens, by Oxford Free Press. I think it's 2006.
So, if it was published in 2006, would it be appropriate to think that that's the black?
Yes.
Because it really sounded pretty limiting from what I was understanding. It sounded like there was a lot of limitation based on what he was reading. So that would all be on the public side. But if we go into in camera, things change.
Yeah. Keep in mind that 33 being the pivotal point, whether everything's post or supra. So our interpretation to keep it in context. Whether it's pre 33 or post 33. Be very easy to get confused if you didn't.
So really, everything he was reading was to continue to keep the prescription going.
Yeah, I would think so. Now that I understand that maybe he was not reading something that was older, pre 33.
Yeah, for that one, really, you need to look at the Agency and Trusts book, pre-33.
And that's the one you read a little earlier before that.
No, I never touched on that one. It'd take me too long to filter. Bookmark it, maybe for tomorrow or next time.
Wasn't that first one you were reading through was the agency one, the 54-page one?
Nope.
Okay.
So tonight's call was really a lesson of recognition in the black in order to see the white. That's really the overall message, right?
Well, it might be that way now. I wasn't really realizing that he was reading something that new. I thought he was reading something pre-33.
So does that skew the way that you feel about all of it?
Yeah, I would think I would have to have a bearing on it. Yeah, I wasn't paying much attention to that. Now that we talk about that, yeah, that would have to.
Chris, and just like you talked about Gilbert's being all in the black, to me, I mean, everything post 33 is going to be black as well. It's just designed to keep the prescription, keep us in the dark, and keep us fighting each other through debtor creditor.
Correct. Right.
So not to take anything away from all Pete's wonderful research effort, but if we're going in camera, does really any of that apply? Because we're making the rules. We're the king.
Yeah, I think the older stuff applies. Yeah.
But I'm saying, does the stuff that Pete was reading tonight apply to our long-term endeavors here?
Right? Yeah.
I'd have to review it now, really.
They're going to let me know I need to be like what I said.
Okay.
It was pretty much the basis is that, you know, when an agency is used, the donor, grant or settlor, gives away all rights, title and interest to the agent. And because of that, the agent then can use his donee position.
I'm sorry, Pete. There's some background noise. I can't hear you real quick.
Okay, it was just about the the relationship of agent, which is donee. When the donor gives the instruction or the property to the agent, then the agent has the discretion then, outside of a discretionary trust or a fixed trust. He's been appointed agent until such time as he sees fit to appoint a trustee. I think that scenario, black or white, is pretty much the same. I would imagine, and I think it is.
How can we tie that back to Scripture all the way back if we're going to go and we're going to apply it in the white?
Well, who's the agent?
Yeah.
The Pope, maybe.
Okay. Or depending on what country and what religion you follow. Well, I guess it's really the...
Well, it boils down to trustee and ownership. It has nothing to do with your religion.
Right.
This is about right, title.
Trust res principle. Well, anybody else got some comments?
Oh, I did, didn't I? On you were talking earlier about diplomatic status or ambassadorship. If we look at international law, an officer of a commercial character, this is a consul appointed by the different states. So if we look at Montevideo Convention and its definition as of a state, the state as a person of international law, following qualifications: a permanent population, a defined territory, government, and D is capacity to enter into relations with other states. So the way we kind of looked at it when we were looking at this type thing was a permanent population of 1, a defined territory would be your body, the government would be your mind or soul, and the capacity to enter into relations with other states would, be your faculties. So at that juncture, an officer of a commercial character appointed by the different states to watch over the mercantile interests of the appointing state and of its subjects in foreign countries. There are usually a manner of consuls in every maritime country, and they are usually subject to a consul, who is called a consul general, The word consul has two meanings. It denotes an officer of a particular grade in the consular office. It has a broader generic sense, embracing all consular officers. The official designations employed throughout this title shall be deemed to have the following meanings respectively. First, consul general, consul and commercial agent shall be deemed to denote full, principal and permanent consular officers as distinguished from subordinates and substitutes. Second, deputy consul and consular agent shall be deemed to denote consular officers subordinate to such principals exercising the powers and performing the duties within the limits of their consulates or commercial agencies, respectively. The former at the same ports or places, and though later at ports or places different from those, this is in blacks first, by the way, those at which such principals are located, respectively. And then there's vice consuls as well. Now, what was interesting about consul was that a consul is also known as a envoy extraordinary and diplomatic rank. So, following that sort of rabbit trail around, we come to customary international law. Now, customary international law are those aspects of international law that derive from custom, coupled with general principles of law and treaties. Custom is considered by the International Court of Justice jurists, the United Nations and its member states to be among the primary sources of international law. For example, laws of war along a matter of customary, and you can find that on Wikipedia, customary law before they were codified in the Hague Conventions. The vast majority of the world's governments accept in principle the existence of customary international law, although there are many differing opinions as to what rules are contained in it.
It all comes down to commerce.
Yep. And commercial agents.
State.
Hey?
All you need now is an act of state.
Yeah, a treaty with other states.
You already have that.
There you go.
Scripture. Scripture says that we're all ambassadors.
Yeah. Mm-hmm.
So
now,
that's.
Have you looked at the Nicene Creed?
Yeah, one time I did. I forget what it was. All involved.
It talks about Jesus came down from heaven to be made as a man.
Mm-hmm.
The only problem with that is Constantine was in control of that. He was the Pope back then.
Yeah.
But it still has a reference of Scripture, and I know someone that has done a ambassador passport. I've got to get in contact with them, and they've done extensive research in this area, relating to Scripture and also with the UN, international law. So I'll get a hold of them and see if I can get a little bit more information of how they cross-related in using it, because they're using that right now to travel the United States of America, and they get pulled over all the time, and the cops read it, and there's nothing they can do. But the only problem is that you have to be recognized by the UN, but they come into play ecclesiastical ambassadorship. You can claim that under the Vatican using Scripture. Not saying that you're following their beliefs, but under Scripture.
Is that American passport issued through a U.S. Secretary of State that is an ambassadorial status?
No, it's an ambassador's passport that they made. They made themselves, and they're using it. And the only thing is getting it recognized. And I think possibly if we get it recognized by the Secretary of State and possibly attaching that documentation to the Declaration of Independence, and thereby the United States recognized you.
Well, I think that's the whole process we have to go. Our group has talked about this at length. You know, we when we are getting off the soil, we're elevating ourselves into TSA and United States land to cross over into Europe or wherever we want to go. We have to go through a border control, and unless we're recognized by the Secretary of State and they have the TSA, for example, has a record of us, has an ambassador or some other status.
Legal.
It's just going to be like everything else. Yeah, good luck. All those other non-government issued documents are going to be thrown in the trash, or you'll be harassed. I personally don't think any of those things are ever going to work. It might work once if you get a guy who doesn't really know what he's doing, but if they're doing their job, it's just going to be a problem.
Yeah. I know one guy got in really trouble with documents. But yeah, it comes boiled down to that if you don't have the recognition in that realm, you're really illegal.
So that's why you have to submit it to the UN for recognition.
Yeah.
Well, either the UN or the Secretary of State has its own separate, division for people like us that are going to be non-resident aliens and ambassadors. I mean, I'm an American. I was born on the soil. I deserve the status and the protection and the ability to flow freely through United States TSA and security.
So that's where it comes into play of shuffling the papers around or doing the WBNs and everything else and notifying them. And once that gets notified, then basically you can send it up
Yeah, that's I think is a key point. Correcting that individual master file, because whatever you do, if you haven't corrected that, all those other agencies have got to comport to that. So if it's off your individual master file, everything else is going to be skewed too.
Yeah, because once the master file,
like that's another.
Once the master file is squared
That's
away,
thing that we need to do to. Go ahead.
Once the master file is squared away, I think some other things are going to fall into place. It's things that we don't know right now. It's just the initial thing is getting that into play, and it doesn't that take 160 days or 190 days?
Well, I think international.
Pardon me?
I think international is 120 days.
Okay.
So that sounds like another task we need to figure out what we got to do is when it comes to getting these ambassador or diplomatic documents, whatever that process is exactly, and who to go to might be another thing that somebody in this group we have could follow up on to figure out what.
There is something that
ask them, what documents do I need? Do you have all the documents that you need to process this and put it through? Either a simple yes or no question. If they say no, well then, okay, what documents do I need? Provide me with the documents. I direct you to provide me with the documents I need.
I feel confident when the IMF is corrected that all those pieces, all those questions will fall into place. Once they look at your file and see who you are, it'll be a cakewalk after that.
Yeah, and then continue to act like it. So because your actions are gonna, up in step with what you say. Can't cross back over in that debtor creditor line again.
Because they'll construe it.
Yeah. Won't make it again.
I agree.
Actions speak louder than
Christian,
words.
I got a question for you. It's a little off topic, but where exactly can we find out that when we merge titles, that there's dispersion? Is that in Gilbert's?
I think it's 159 makes reference to it, and there's another section there. That was in a restatement, I think it was. We're talking about merging titles around 342, 345. Oh, you broke up. What did you say?
I said in the second restatement, is that what you're talking about?
Yeah, second restatement, section 342, 345, somewhere in there, without me looking.
So from a technical standpoint, when we claim the titles and then we move the titles and we have our 2 witnesses for each, and then you send those documents to whoever party you're talking to, are you going to want to also give them a cover sheet, much like we've done in the past, and basically tell the new trustee what to do with that, and then give them, say, 20 days if they don't either correct the record, offset the books, or don't give you your receipt back, maybe give a second demand for the receipt because you're nice. And at that point, maybe after that's cured for another 3 days, you can go in and probably at that point open up a claim against the trustee.
That would be one way I could do it, yeah.
Until we get to the point where we chop the root out. And to me, you have 120 days from the time to get your documents submitted for the IMF correction. We have another period of time before we start those, a period of time to create them. It's 160 to 180 days out, probably before our IMF is going to be created and or modified, and we have the full record that's completed for us and ready for the DIB hearings for whomever is discussing any matters with us. So we have, 5 or 6 months of before we're ready to engage in other areas, which means that we're going to have to work with the tools we have, whether it's debtor creditor, or take any presentments, turn them into special deposits, and then work with them that way. So these are all sort of buying time for the master file correction, as I see it. And if you get a presentment and you turn that into a special deposit, you want to give them a good set of instructions that expresses the trust, tells them what to do with the deposit, tells them not to commingle, tells them to set off discharge, any past, present, or future obligations, and then just like in debtor creditor land, give them time to do that, and then maybe do a follow up with notice and demand for that the record has been corrected. That if they have not, please return the special deposit uncommingled. At which point, if they don't, then you have recourse to open up a claim against them for breach. That's sort of what I'm thinking about in the intermediate steps.
Now, that brings up a pretty interesting question. If we're bringing up a claim against them for breach and we're doing all this privately, do we bring up a claim on the statutory side, or how do we bring that up for damages?
That's my thought. Yeah, you go straight into just where you're going to end up, and you claim all of the causes of action that you have against the trustee who has failed the trust. And when it comes time to proving it, that's all in private. That's all in chambers and camera review. So you don't release any of that, but it's still going to be a colorable cause of action.
Does everybody else concur?
Maybe better repeat that again. I was following this other thing I was looking for here. Repeat that again, JC?
I was just simply saying that you want to keep it colorable. So once you send your special trust deposit in, you give them essentially a cover sheet that expresses the trust. You send the documents that proves the trust, and in there you give like a mini indenture that tells them what to do with the res. Tells you if it's if you get a presentment, you send it back. You tell them because you've merged the titles as payment in fact, you're going to want them to settle and discharge any claims they have against you, and then you give them the time to cure. Give them 10 days to complete that correction, or 20, or whatever time frame you want. So it's almost mirroring debtor creditor land. You're going to ask for a receipt back of whatever action they took. They won't send it to you. So then you'll give them a second notice and opportunity and give them 3 days to complete that. And at that point, then you can just go ahead and claim that they've breached the trust and go to district court and open up a case. That has all the colorable causes of action that you need. You have your record of expressing, proving, claiming the trust. And you also have your notice or your record that you demanded them to fix the record. You gave them opportunity to cure. And so now you're coming in with clean hands. So it's a bit of a debtor-creditor hybrid, but you're using the trust res as a deposit.
Yeah, I would basically agree with that, but then I'd watch out for the weak precatory language in there. So.
Right.
So you agree that even though we're expressing a private trust, we use the colorable side of the court for cause of action for breach?
Both sides, yeah. You have to use both sides.
Okay. Okay. And
I have
under that, that manifestation of intention, and where it's section 23 of the second restatement, where it says that it is immaterial whether or not the settlor knows that the intended relationship is called a trust, and whether or not he knows the precise characteristics of the relationship which is called a trust. That's a quote right out of it, section 23. And it's also on page 19 on section 67 of Gilbert. I was trying to find the merging in there. That's what I was looking for next.
I know we've talked about the trustee. Nobody has to know that a trust was created. I just think from a clean hand standpoint, giving them instructions, putting them on notice that the trust has been created. Here it is. The title's been moved. And
well, I had somebody email me and basically tell me I didn't know what I was talking about, and really this guy doesn't know what he was talking about because it's in there. He says, how can somebody not know? Well, I'm sorry, I didn't write these things, I'm just quoting them.
Right. No, I agree with you. They don't have to know.
No,
they've been working that against us for 70 years.
Yeah, the fellow didn't apparently get on the call early enough to hear me talking about the examples of, hey, when I give you my pen and I want my pen back, then, if you just think about that example, it proves that I didn't know, you didn't know, nobody knew, and it really only comes down to knowledge and understanding when I have to enforce it. But it's talking about when the trust is formed. Nobody has to know.
Mm-hmm.
Going to enforce the trust. Now
obviously that guy never been to court.
Yeah.
Well, giving them notice of what you are directing them to do, and that's where, again, you talked about precatory language. Yes, in the quasi-trust indenture, you're directing them to keep that in special deposit. You're directing them not to commingle funds. You're directing them to offset and discharge any obligations, and you're directing them to send you a receipt of their actions. So in doing so, you've given clear expression and non-precatory language, and now you come in with clean hands, and you can move the court for a remedy.
Well, if it's the master trust that you're speaking about, we can only go into one court, and that's the court in D.C.
I was just talking about the intermediate size where we're getting presentments left and right. We haven't the master trust is going to take 160 days, 180 days for us to wind up to take care of. So in the meantime, everybody's got all kinds of presentments coming at them, big or small.
Yeah,
mortgage foreclosures or indictments.
Really focus on the major thing that's causing all the problems.
Right.
They're too busy trying to fight the issues of the leaves of the tree rather than pull the whole tree out.
Well, believe me, I've been very patient. All of us have been patient, and as we study, we research, everybody's pausing intentionally, not drafting documents until we get to the point where we are drafting documents in the seminar.
Unless doing that, wasting the time, so to speak, if we do our research first and then we do it right the first time.
And that brings up an interesting question as far as when we go to express the master. Christian, would it be appropriate for us to buy accommodation on the DOI?
Accommodation. I'm not getting exactly what you mean. You mean to join
rather than shipping a Declaration of Independence around and getting 50 people to sign it. I suggested that maybe you can get a power of attorney for that sole purpose of that signature. At least within our group, send it all. We'll get the signature signed by accommodation for that party and put their name on it.
Okay, I see what you mean. Yeah, that could work. Yeah, you could get an accommodation signature, right? Yeah, give everybody power of attorney. Then one person puts all the names on.
Mm-hmm.
And another question, JC and I were talking about administrative process, and as far as what part of that is actually CCI, and is it the initial presentment, the notice of fault, opportunity to cure, or is it strictly the dishonor that's actually the CCI?
What would be the CCI? The dishonor, the notary presentment, and what was the other ones?
The opportunity to cure, notice of fault, opportunity to cure.
I think my opportunity to cure and the fault and all that is, that's all CCI too.
Yeah, actually, Christian, the question really came up was whether the initial claim. So the claim is just that. It's like any other presentment that goes out the door with a single signature on it. They didn't agree to it yet. There's no tacit procuration on that. It's just simply you sending a contract to them, or agreement to them, rather.
Yeah, just the notary broke arms.
Exactly. So to me, that's not the CCI, even though it has essentially all of the elements that will be agreed to, but it's a one-party claim at this point. So the CCI comes in to me.
It's a public notice.
Yeah. So even if that claim goes out and it's a private administrative claim, even if it goes into the public, I don't think it damages the CCI, because the CCI is where you have the notary, the notary notice of dishonor, and that's the key right there. That's their agreement between the parties.
Yeah, that's where the CCI comes in and diverges from the notice.
Great. That clears up a lot of things, because then actually what you can do is just like you can allege that there is a trust, you can also allege that there's an agreement between the parties, and you can use a claim as an attachment to your affidavit that agreement between the parties exists. And then when the opposing counsel comes in and says, no, we don't have agreement between the parties, Your Honor, we do, and this is commercial confidential information. I can't talk about that in court, but we can do it in chambers can review, and let me bring you their agreement between the parties.
Yes, right. You're right on. The notice is just the public declaration of a claim. And like you said, the other stuff was all in chambers, and that's where I'm going to prove my claim. Merger. There it is. Finally found it.
And this is the second reach statement as well?
Let's see. Is it on the second or the third? This second. Second restatement, section 341, merger. Says 1, except as stated in subsection 2, if the legal title to the trust property and the entire beneficial interest become united in one person who is not under an incapacity, the trust terminates. And 2, if the beneficiary of a spendthrift trust having the entire beneficial interest in the trust property becomes without his consent the sole trustee, this might bring some things that we've been talking about earlier, he can procure the appointment of a new trustee and have the trust reconstituted. So I'll read it again. If the beneficiary of a spendthrift trust having the entire beneficial interest in the trust property becomes without his consent the sole trustee, he can procure the appointment of a new trustee and have the trust reconstituted.
And if he failed to appoint a new trustee, it would disperse, and he would have to take the trust as, right, as a beneficiary?
Okay, say that again. He would have to, if he doesn't appoint a new trustee?
If he failed to appoint a new trustee, then the trust would have to be dispersed, correct?
Or resulting
No, because there's not merging of titles.
Yeah.
Or resulting
trust with one.
Okay. And potentially resulting discretionary trust, right?
It says that he can procure appointment of a new trustee and have the trust reconstituted.
Right, but if he failed to, not only would it be a resulting trust, but it could also be a resulting discretionary trust, right? For somebody else to take
breach of trust
control over?
It might be a breach of trust. If he didn't appoint a new trustee.
Because the fatal combination is the trustee and the beneficiary, right?
Yeah. Anytime the two titles merge in one entity, yeah.
Okay, so he could either become the trustee and appoint a new beneficiary. Would the beneficiary be able to appoint additional beneficiaries? Or is that only for the grantor?
If been given that right in the indenture, yeah, certainly.
Okay. If he had that, then he can appoint another beneficiary and then become the trustee, and then the trust would survive, right?
Uh-huh.
Because then the interest wouldn't be exactly the same.
It's like the grantor, he's got the total say-so, however the trust is going to turn out, in any particular way that he wants it. It's only in the modern view that they've construed under the IRS laws, under statutes and codes, that it turns out that they don't like to see the grantor being the beneficiary.
But that's all statutory anyway.
That's all statutory anyway.
So then the next thing that the original question on this was disbursement, about where we can find that at.
Disbursement?
Yeah. When the titles merge, or and what will force disbursement? Well, the way the indentures are written. Well, the trustee has the duty to pay the bills of the trust, so he has to disperse
that's,
if the benefit.
That's 345 under the restatement of second. Duty of trustee to transfer title or possession on termination of trust.
345?
On termination of the trust, it is the duty of the trustee to the person beneficially entitled to the trust property to transfer the property to him, or if the trustee has possession but not title, to deliver possession to him. That's 345 under restatement of seconds. And then you might want to, under special deposit, keep in mind section 342, which is direction to convert. So direction to convert under 342 is, although by the terms of the trust, the trustee is authorized or directed to convert trust property on the termination of the trust, the beneficiary, if not under an incapacity, can require the trustee to transfer the trust property to him without converting it. So you got an option.
And listening to this, and then what Pete was talking about earlier, it sounded to me, from some of the stuff he was reading about, even though it was statutory, that the titles were real confusing because there was an owner trustee that he was talking about earlier, right?
Yeah, which sounded like he might have been, the trustee could be a co-beneficiary also. I remember reading that in Gilbert someplace.
And it sounded really confusing trying to listen to what the message was that was coming through from what Pete was reading. But sounded like it was really like a hybrid kind of thing is what it sounded to me when he was reading. Did you kind of get that too?
But I think it was pointing out the fact that the trust really hadn't formed yet because there hadn't been a transfer of trust property yet. And really there was no trustee, no trust, and therefore there was no duty. And I remember reading someplace else in Gilbert's there that upon that situation, the trustee could take the property for himself because he was under no obligation to form a trust.
So does that just revert right back to debtor-creditor, really?
Well, yeah, it would probably have to.
Formed?
But remember that was talking about statutory trust, but Gilbert's, I mean.
Which is, I guess, in its most broken down form, debtor-creditor anyways?
Pretty much so.
Okay, because I mean it's either black and white. It's either debtor-creditor or private trust, right?
Because they're considering it that they can transfer your rights so that they can tax it for a value, so that the creditor can get at the assets. Where 1776 Declaration of Independence says plainly, you have unalienable rights, and unalienable means non-transferable. Period.
So when we break it down, that's what it really breaks down to. It's either private white or debtor-creditor black, even though they call it statutory trust.
Correct.
Okay. That kind of helps clear up what Pete was talking about earlier. It makes a lot more sense.
Christian, can I sidetrack for a second? We were talking earlier about the Secretary. Truth brought this up in our conversation yesterday. Title 46, Section 1247 discusses the appointment of Secretary as trustee or receiver. So we were talking about to whom some of these documents should go. Again, that's Title 46, Section 1247. And it discusses the appointment of the Secretary of Transportation as a trustee or receiver.
Yeah, but under what law form? Statutes and codes?
Statutes and codes, yes.
Yeah. So that would be the public debt side, I would say.
Okay.
And I think Rio was on the private side.
Wow, that explains a lot. So would that be, for example, the office, I think it's for public debt in West Virginia, out of there?
Well, I don't know if it's through there. I think it's, the public debt is probably administered out of the Treasury on the public side where Geithner is. But the treasurer of the U.S., that's Rios on the other side.
So does that mean that there's two treasuries, or there's one treasury with a public and a private side?
Well, actually, the names are like backwards. One is like the United States Treasurer of the United States, and the other one's the U.S. Treasury.
Correct.
If you look at a Federal Reserve note, you'll see you got to look at it like looking in a mirror. You got to put it in a mirror, and if you look at it in the mirror, then it's not backwards. But the black, running in the black, you're in the money, and the black seal is on the left side where the assets are, which is reverse. Assets should be on the right side. And one thing about it,
how did you figure that out?
We did a study on the Federal Reserve notes there. The portraits on those Federal Reserve notes, they're not all dead presidents, which everybody thinks they are. But the one thing that they all are is they're all dead postmaster generals. They're all postmaster generals at one time. All those portraits. And your post office was the original bank before the formation of the United States, before the formation of America in 1776. The post offices exist. That was the original bank.
And Rios is in charge of the mint.
Yes, that's where the bank is. That's the post office.
That's what we're basically accessing our code or through the Social Security number.
Yes. We've been presenting our stuff in the wrong wrong department. Although they're on the same floor from one another, 1500 Pennsylvania Avenue, their offices are just down the hall from one another, or their mail drops.
Yeah, we've been sending everything to the public side, not to the private, so they're ignoring us.
Yes. And another thing, we haven't been putting it under a trust, under a special deposit.
Absolutely.
And all we've been doing is just creating bigger debt, and they've been loving us all for it. And then they discretionary granted us a remedy whenever they spin the dice to make it look good, so that it keeps you on the debtor-creditor path.
So to really get some answers, maybe an interesting study would be to look at Rios' career to figure out if she came out of the post office?
No, study the post office prior to, say, 1968, before it changed hands into the U.S. Postal Service. And now the post office exists only in head form in D.C., where there's only 5 postmaster generals in existence today, and they're all in D.C.
Maybe we need to address the postmaster generals in regards to being them the trustees, because that was the original bank.
Well, that could be something there.
And I wonder if the postmaster generals, if they've expatriated.
Well, I think Rios probably had to.
And if any of them is expatriated, would all their documentation be filed in the public for us to be able to access and research?
Well, that's what I was kind of wondering, whether or not it was the same type of expatriation that everybody is familiar with, that they all speak about expatriation. What actually did Clinton do? What actually did those people that Geithner and those guys, what actually have they done? And what kind of passport do they have? But under Section 342, conveyance to trustee, here's another good one. Conveyance to trustee or at discretion of the beneficiary. Section 342, conveyance by trustee to or at the discretion of the beneficiary. So if there is a sole beneficiary who is not under any capacity and the trustee, notice how they put it under any. If we're not doing the duty, then we are under an incapacity because we're fools. We're incompetent. So not under any incapacity, and the trustee transfers the trust property to him or at his direction, or if there are several beneficiaries, none of them who is under an incapacity, and the trustee transfers the trust property to them or their direction, the trust terminates, although the purpose of the trust have not been fully accomplished. Some of you ought to study the wording that they use on this, because they're always using direct, order, command.
And again, that's in the second restatement, right?
Yeah, that was the second. Because we need to stay away from particular wording, Request. That's a word we want to stay away from. Offer. We don't offer anything up. We order. Order and direct. Hope. I hope.
Prayer.
Yeah, prayer. I wish.
So the whole legal industry really trains people to use precatory language.
Yeah. Mm-hmm.
Okay.
Wonder You know, you said on Saturday, Christian, about looking up the word, the term bill of equity, bill of equity.
Yeah.
I started looking through a book that is all about bills of equity, and there were several, and one of them was a prayer.
Okay, I think I might have said equitable asset.
No, you said look up bill of equity.
Bill of equity. Okay, that was one of the other ones too. But one of the recent ones I said also look up equitable asset.
Okay, because we were looking up equitable lien. That was interesting. Kind of a similar thing, I guess.
Asset,
but yeah,
interesting term. Equitable asset. Let me find that one.
The word prayer was or is used in equity as a bill to petition the court. You can find it in Black's First. I'll just have a quick look and then.
Must have been the wrong one. Must be under the 8th edition. I thought it was in the 4th.
Christian, a question just came up about court procedures. On the colorable side of the court, when you're motioning and making pleadings back and forth, you can't order the court to seal records. All you can do is motion them.
Right.
Is that correct?
Right on the colorable side, right. Yeah.
I mean, there's the court, the judge is the judge is according to the judge on the colorable side, she's going to feel all powerful, and she can admit, deny, or reject, strike. She has that ability to keep her court orderly. So all you do is motion like a little schoolboy.
Yeah, I got to act over there. You got to act like the fiction. Got to put the mask of the fiction on over there.
Prayer at Black's Fourth. And it starts out with the request contained in a bill of equity that the court will grant the process, aid, or relief which the complainant desires. Also, by extension, the term is applied to that part of the bill which contains this request, precatory.
So, if we're coming in as grantor to a trustee in a newly formed trust, for example, what I did is I got court and it was saying the judges said treat your claim as a application or something like that, and we've added in the application forms. And you need to send us some money. So I wrote to the woman doing business as such and such, to explain how or why she's put in the application forms, but I've ordered her to explain. So I'm telling the trustee now to say, what are you playing at? What do you think your role is? So I'm not speaking to the fiction, I'm speaking to the woman, and I mark the envelope strictly private and confidential.
And what response have you gotten, Pete?
I only sent it today. Sorry.
That's my biggest concern is once we can send things to the private, but that doesn't mean it's on the record.
And it
so
also,
if you're talking, go ahead.
What I'm saying is, it's a trust. She's written to me, so now I'm granting her a trust. So I'm bringing her in trust straight away.
Okay, how'd you word it?
Well, I used let me see, I've got it here somewhere. 1 second.
What was your trust res?
The letter that I'd given her. I told her to keep hold of it.
Here's the definition of equitable assets. Equitable assets are all assets which are chargeable with the payment of debts or legacies in equity, and which do not fall under the description of legal assets. So those portions of the property which, by the ordinary rules of law, are exempt from debts, but which the testator has voluntarily charged asset, or which, being non-existent law, have been created in equity. They are also called because they can be reached only by the aid and instrumentality of a court of equity, and because their distribution is governed by a different rule from which governs the legal assets. Black's Law, 4th Revised. We have equitable assets that operate under a different law form.
Yep.
So that really sounds like special deposit all the way, right?
Yeah.
Just like Pete's letter.
Pete, did you tell her what to do with the letter? Did you give her essentially a mini trust indenture?
Yes. What the judge said in his comments, which is verbatim, is treat the defendant's letter as an application to set aside the order for the 5th of January 2010 and list on the next available date before any district judge with an estimated length of hearing for 30 minutes. And it was funny that he said before any district judge, on 5th of January, I made him trustee. And now I've written, now you have sent me an application form N244, which you have stated that I must complete as a formal application and return to the county court bearing the address blah, blah, blah. And it must be returned with the required fee of £75, which states clearly that it's a promise to pay the bearer on demand, whereby such instruments hold no value at said financial institution. Define for me the word payment, and I can check if it corresponds with my law dictionaries. Therefore, you are ordered to validate this alleged debt when it clearly states by the judge, treat the defendant's letter as an application, and there was no monetary or other obligation of performance to return of like value mentioned upon the defendant's letter. You are directed to disclose capacity in asking for payment. Would this be a private non-negotiable no for tender that you seek, or are you asking for, in my business capacity, of which I am in no way acting, to perform an obligation to you, yourself, a living woman doing business for the district judge's section, to provide you with like species of financial instruments? The trustee for that account is the judge, who was appointed by me on the day, as is recorded. Do you have proof to the contrary? And such and such, and then my intention is for you to act as trustee, and here are your duties. You are to hold this document as a special deposit. You are to answer all commands, order, and directives set by me. You are to retain any and all equitable interest to me, beneficiary, and then signed by settlor beneficiary.
The trick is putting the indenture so it's not looking like an indenture. Has anybody done any Xing on that? How do you make it? If I give you my pen and I want my pen back, although there was no wording in there about a trust, yet there was a trust form. Has anybody worked on any verbiage of getting anybody into a trust without putting any trust terminologies in it?
See, I was going to be colorful about that. I was going to be explicit and tell them that through the assignment of the enclosed documents, you are hereby, blah, 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 making them the trustee, giving them the obligation, putting them on notice to settle and discharge the account, not to commingle the funds, to direct them to send a receipt back with the full accounting, and, you know, a few other pieces in there, but that's essentially the gist of it. I don't know if I need to tell them that who the parties are, that this is the res, but essentially they'll probably, anyone who knows anything about trust will probably get that. And certainly the judge in private will understand that direction and what you're doing with that. There's a hint, it's like seasoning of trust in there, but the meat's there.
But did you put the word commingle in there?
Commingle will be in there. I haven't drafted that yet. When I do, I'll email it to you. But yeah, I think that cover sheet I think that's important because you have to tell them not to commingle it, that you want you want your trust, your receipt back, here's a certificate of deposit, you want an accounting, you want an offset and discharge. You're giving them 20 days to do so. And I think you follow up with a 3-day letter, and that keeps your hands clean, and you know, you directed them at every step of the way.
There's a guy in our group, he sort of says that the indentures need to be, you know, quite lengthy and written out as terms and conditions.
Yeah, but I think
when we go to court, they don't do that.
Lengthy.
Sorry, Christian?
I think it's to be more crafty than lengthy.
Yeah,
and we can
I agree.
express trust as being so simple as saying, you know, here's my pen, I want it back. I want my pen back. Now, everything is there necessary for the formation of a trust. Now, when we become that crafty, it comes down to taking the word, you know, like, all right, what is it that's necessary? Well, it's going to be a present transfer of property. And when we presently transfer the trust property, how are we going to say that we can't use in kind, we can't use commingle, we can't use, say, segregate? Because really, you said all that when you said, I want my pen back. How do we be that crafty? Let us be as wise as serpents and gentle as a dove.
Christian, when you say you want the pen back, that is the same thing. You want your identical pen back, not a pen. You want the pen. And that's exactly you want your pen back.
Huh?
Right. And so when I direct them to settle and discharge, you know, the matter, the instant matter, and then return to me any surplus or anything else remaining along with a receipt. That's the exact same thing. You're asking for a return of the balance of whatever you gave to them. So essentially, by demanding that back, yeah, you're not telling them not to commingle, but you're demanding the proceeds
that would happen
of your
commingle
pen
if
back.
they was get my pen back.
Christian, the whole reason that you threw that out there about being crafty is because that's exactly what they're doing to us.
Right.
So then maybe the way
expressing
we could learn to do that is just
knowledge,
follow their model.
us into a trust very craftily. When we stop,
So you said
we don't have the practice of drafting any indentures that don't have any specific things in there that are craftily written.
Yeah, but wasn't the thing that was written really well way back in the preamble of the Declaration of Independence that put us in the trust, named them as trustees? That automatically makes us as the grantors. So everything we give them is under trust. We don't even have to.
Everything is under trust. Trusted to be a trust. But then how are you going to get an agreement for, say, a checking account or a something that you're going to sign, say a mortgage contract? How are you going to express it as a trust when you're going to sign by grantor and all of a sudden they don't want to take that?
Well, you just tell them that's my signature. You got to take it.
Okay, so what? And they said, we still don't want it. Go get your mortgage. Oh.
You know what? You're right. I don't need the mortgage because I already got the note and I took it down to the courthouse and already had it certified or registered. So my house is or whatever's already paid for because I just got my.
And you're there for the first time and you've never had a mortgage before. And you want to get this house and you're under the dire straits and you want that house, and you're under the temptation that you got to have that house and they're going to tell you, no, you can't sign that way. What are you going to do?
I just signed that way. What law says I can't sign that way?
Well, it's against our public policy, and I'm sorry we can't grant you the loan.
Well, I guess I'd file a paper first that says X means grantor and then my name, and then go file it on a UCC-1 or file it with the courthouse that X means that, and then just sign X.
The point is, can we craftily word something that we don't raise all kinds of red flags? Is there some way around?
Christian?
What's that? I didn't hear you.
I said, is that an assignment?
Well, yeah. I mean, you should really start thinking about this stuff. How can I word something craftily? Because that's what they're doing to us. Why can't I word crafty to them?
Are you saying just do it as natural?
Kind of. Yes, because that's the more natural it's going to become.
Yeah.
I think
and then
you hit on the head, Christian.
Natural law.
Is it intent to grant your permission to transfer the title of whatever it is to so-and-so? Or this is the trust res, and I direct you to please separate my records for future return?
If that's the case, then what model do you think we might want to look at that they're doing that's so crafty where we can easily see that it's a trust, but they're construing it to something else potentially if we don't express? What's a good model maybe we can all first look at to
I think if we use
all come together?
Example, I give you my pen and I tell you I want my pen back. We just formed a trust and we had all the elements and the method there already, and that's the trust. But yet what was so simple was I just said I want my pen back.
Yeah, maybe, I don't know, maybe
I'm going to get it back, and you guys not commingle. You have to separate my pen from every other pen and give me my pen back. Because I'm giving you in kind my pen, and I want my pen back. It's as simple as that. That's when I gave you the pen, and that's when the transfer of trust res property took place. And the only thing I said was, I want my pen back.
I think that would be fairly easy to do if you're going to craft a document, but to hide it on your signature on their forms, that would be the tough part. When you said, the example you gave, the mortgage, well, how do you hide grantor in front of your name?
Yeah,
three dots.
Three dots, and then my name.
I'll give you a real world. Ruben and I actually have been playing with some of these pieces in the public And it started off with going to the DMV and signing our names. My driver's license says by grantor my name. And the DMV lady looked at it and she says, "We can't take this." And there's this brief debate between the man and the woman behind the counter about whether they take that. And the guy finally said, "What's the difference? Just give it to them." And so, it rolled through. But there was a moment where I said, well, I had to say that's my legal signature. I got it. I went down to the bank and I expressed a trust. I re-signed my signature card as by grantor with my name. And I get a phone call 3 days later from their compliance department that says that we can't take this document. And I said, well, why not? She says, well, we don't accept signatures like this. And I said, well, that's my legal signature. That's what's on my driver's license. If you'd like a copy, I'm happy to send it to you. But that's how I sign my signature. They haven't closed the account. I haven't heard back from them. So I'll probably pull my bank signature card again probably next week and just see if they put that in there or if they disregarded it. But I think the 3 dots is the key. And I also, so there's 2 lessons in that. One is I think the more we interface with the public, the more we learn. We have to keep probing. It's just probing their defenses, seeing what works, what doesn't work, and how to keep things going. That's one. And 2, I think the being as colorable as possible is like the serpent, and having those 3 dots in there as small as can be, but they're there, and you can clearly express your intent by in chambers to anybody and defend it. I think that's the key right there.
So what does the three dots preceding your signature signify?
Okay, if you look up in any law dictionary, you'll see a lot of examples of the like 3 dots, and they're reading through something, and there's a part missing.
Okay.
The 3 dots signifies there's something missing.
Right. Okay, I do that, but it's usually after something, and then I start up again. Okay. And then can I ask?
It's called an ellipsis, which is ELIPISIS or something like that.
Okay, thank you. And the guy that signed his driver's license by grantor, was that by any chance on an electronic signature pad?
It was not. It was actually on a little 2x4 piece of paper, and they scanned that along with the digital picture that they took.
Okay, yeah, California, they give you this blank, I guess like a computer screen to sign. So it's pretty tough to. Well, I guess it wouldn't be, but I think when they do it electronically like that, I think if they don't like it, they just erase it and just leave your signature. But
Christian, can we sidetrack for a second? We've had some questions about actually completing the blocks 1 and 2 on the UCC 1 and 3, and how we're filling those pieces in.
Okay, yeah.
Are you just coming in as the all caps straw party? How are you filling in blocks 1 and 2?
Well, remember, all the nomenclature on both those forms changes according to the one down below that says, leasee, leaseor, grantor, or bailee, bailor.
Mm-hmm.
So all those terminologies on that whole form up above, secured party, all that stuff, that all changes.
Based on what you check.
Non-UCC filing, as say, if I put in that, I think it's block 7, where I could actually write in, say, grantee, grantor, and say, put in a check there, and that's my terminology. There I got my grantee, grantor terms set up there on the form if I wanted to.
I'm sorry, can you say that again, Christian? I was just pulling up the form. I wanted to follow with that.
Optional block, where we would sign sometimes. You could actually put in there in that optional block there, grantee / grantor, which would conform to the nomenclature up above, and I think it's block 5, where they have the bailee or bailor filing. Because actually the first one would be, say, trustee, or because it's bailee / bailor, so that would be like trustee / grantor. or would be the last one in the sequence to follow suit. Put that same terminology and change all the form to that. As grantor / grantee or trustee / grantor, grantee / grantor, whatever you want to use.
That's block 5. It says alternative designation, and it has a lessee, lessor, consignee, consignor, bailee, bailor, seller, buyer, ag lien, or non-UCC filing.
And then the / and the ORs are next. So you got to put like trustee / grantor or grantee / grantor, and I would put that in, what's the block down below, block 7, optional block?
Yeah, there's, block 7 is a checked request search for reports on debtors. 8 is the optional reference data.
Yeah,
block 8 is
optional
optional reference data.
We used to be able to use, we'd go in there and we'd sign our names in there sometimes also. But you could use that block there and put that grantee / grantor in there and put a little block and check that. And put that as the designator for, like on block 5. And now all your terminology in blocks 1, 2, and 3 all change.
I think it's also quite proper to put trustee, trustor. Trustor is another word for grantor.
Yeah. Settlor, settlee. Settlee, settlor.
Right, if you do settlee and settlor, then number 1 is debtor, legal name, and so you just substitute, say, trustor for debtor.
Okay, first one would be debtor, so that would be, say, trustee. So, because we have bailee, bailor, so bailee would be trustee, and that's the first block.
Okay, right.
DEEs is the first block. Trustee, grantee. And the secured party on block, the next one down, what is block 3? That would be your grantor.
And are we going to name beneficiary on here at all?
Yeah, you can change that trustee / beneficiary.
Hey,
those
Christian.
two titles can't merge, right?
Say what? Yeah.
I said, but those two titles can't merge, right?
No. The trustee would be in block 1, and the beneficiary would be in block 3.
Kristen?
CSA is the judge, and the beneficiary is the live man.
Kristen?
Yeah.
This is Michael. I'm signing out. It's been great listening to you tonight. Have a good evening.
Okay.
Eric, you got to mute out.
Okay. Anybody
that clarifies the UCC one. I appreciate that. That helps finish that up. That's good.
Could you run down that UCC one, box 1, 2, 3, 5, and 8 for me?
JC?
Okay. So the first thing you're going to want to do is you want to go down and in the optional reference data or the alternative designation, put your own blocks in as, say, trustee grantor or whatever's applicable. Say you're in a court case, you want to point the judge as trustee. So the debtor, the E, to be the trustee position. If you have additional debtors, you can put them in there. And then your secured party section, that'll be where you are coming in as a grantor. And you want to, of course, check that non-UCC filing. And then those designations will carry over to the 3, so when you assign that, it just flows through. And then block 4, of course, on the UCC 1, I've already seen transcriptions of those 4 or 5 sentences that claim is the operative word on here versus transfer on the 3.
Yeah, okay. I didn't have the form in front of me. I was just writing down box 1, 2, 3, 4, 5, and so okay, that's good. I think I got enough.
I'll see if I can. I'll put together a little template and I'll post it on one of the 4 shared sites.
And who's this speaking right now?
JC.
JC. Okay, this is David. Thanks, JC.
Hi, David. Sure.
Thank you, JC.
Thank you, Christian.
Okay, well, it's about 1:30, so it's getting kind of late.
Hey, I just wanted to shoot out the definition of ellipsis since Pete brought it up earlier.
Okay.
And it's the omission of words or clauses necessary to complete the construction, but not necessary to convey the meaning. That's Black's fourth.
That definition again was with the word what?
Ellipsis.
Ellipsis. Okay.
And how do you spell that? E-L?
E-L-L-I-P-S-I-S.
S-I-S. Ellipsis.
Eric, would you read that again, please?
Sure. Omission of words or clauses necessary to complete the construction, but not necessary to convey the meaning.
So
And
the
think
meaning
about
can be spaced as well?
Mm.
The meaning is whatever your intent was.
-115. If anybody has
Say it again,
UCC,
Christian?
look up 3-115, incomplete instrument.
You broke up a little. Did you say UCC 1-115?
No, 3115.
3115. I'm looking it up right now.
That's what they send us all the time in our incomplete instruments, right?
Right, looking for a signature. Yep.
So now, wouldn't the judge say, "Well, what do you mean by that?" And then you say, "Well, I mean on the grantor," and then he says, "Well, he looks up ellipse, and he says, "Well, you're not allowed to have the meaning there." Isn't that what it says, that definition?
Well, I would object and say, well, if you want to talk about this, we have to go in chambers because that's secret information.
Okay, well, even when you get in chambers and he starts that and he says, "Well, what do you mean?" And he said, "Well, I want to put grantor in there." And then he says, "Well, what do you mean by grantor?" And then he's going to try.
It was my intent and my purpose that there's missing information, and that was my signifier that there's something missing there. And what is missing? I'm going to add the words by grantor in there. The only one could be, confirm your intent and purpose is you yourself.
I like that. It just amazes me how our brothers and sisters that work for these organizations, are, really our biggest enemies,
They're brain dead. They don't know or they don't understand. They're total fictions. You have to have sentior, and when you don't have sentior, you're not a fiction any longer.
They're just conditioned. So again, the ... is defined as an ellipsis, correct?
Yeah. Chris, I have one more quick question about special trust deposits, if I can. And we were talking about, we're going to send a money order, if I'm not mistaken, to Rosa, and that's going to be what she's going to use to pay off either my debt or all of our debt.
Yeah, a money order is really under Section 115 of Gilbert's, which is really merging titles.
Right. Exactly.
The order to merge the title is likened to the BOE or the check or the money order. Although it's not under trust, it's a merging of titles. The merging of the title is the payment.
Okay. Well, that clarifies something, because I was contemplating, well, we could also use a money order, a blank money order, as that special trust deposit that we can still claim and move. But I was trying to contemplate using, again, a blank money order for payment on a mid-level presentment that comes out, rather than taking their incomplete document, their incomplete presentment, and using that, but actually making a money order and telling them to set off whatever the amount is.
Yeah, well, actually, the money order is really to the debt versus the title to the assets, and when you merge the two titles by an order, then you've completed the discharge and the set off. That's the payment.
Right. Got it.
According to the book
really
agency,
no bill of exchange or check or money order used, but it's the merging of the title that is, how do I want to say, substituting as the BOE, but it's under trust instead of debtor creditor. A bill of exchange is under debtor creditor.
Okay, good. Well, thanks for tonight.
All right. See you tomorrow night at 10 o'clock.
It sounded like Pete wanted to say something in closing.
All right. Go ahead, Pete. All right.
okay, it was just that the book agency and trust, it says that you can pay an agent to pay off a debt and the creditor need not know.
Yeah, that was just something I just read.
So, Pete, could you please repeat that?
That was under the restatements. I think
Yeah, that you can pay a creditor and he need not know. You can do it by way of agent. So maybe pay the straw man and, the debt's paid to the creditor.
So is that a way to make it colorable again?
I think it needs further investigation.
Okay, well,
Okay.
I'm going to go.
Thank you all.
So,
Yep. Thanks, Christian. Thanks, everyone.
Good night, all.
Thanks, Christian.
maybe do some checking into,
Good night.
how to crafty wording for an indenture. Just something simple, like I want my pen back.
How can we mess that up?
Well, think about it, an application to an electric bill or something that comes in the mail.
What was that, Christian? What was that, Christian, about something that comes in the mail?
Do it to for an electric bill. Some kind of crafty wording that you're going to turn it into a trust. As simple as I want my pen back.
You're getting us to speak a whole other language than the language we already speak. You know that, right?
Well, I direct you to separate my records for future.
Yep. Well,
All right.
You're so great, JC. Thank you, guys.
thanks, Al.
Okay.
Bye.
Bye, Phil.